Claiming for granting as a training center on 13 below. But I have already mentioned.
Writ appeal is pending since 2013.
No, that to the 22 is writ appeal below. But my claim is pending at the 13 below. Even though the Lordship already had this matter, they were stayed out there, but everybody is getting, but my plant is not getting now. That is a lot.
The appellant.
Yes.
You will see. Give us.
I may be pardoned to mention, Your Lordship. I have filed one CMAPL number 865 of 2023 to restore an AHO, Your Lordship, which was dismissed for non-prosecution. So, Your Lordship may kindly take it. Oblige.
Dismissal which bench?
Since it's arising out of an AHO, Your Lordship will be. Yeah.
That was facilitated with an appeal against appeal against High Court order.
Oblige, Your Lordship.
And may be pardon you. From the list, may I mention item number 5?
Just a minute.
Yes.
Pardon to make a mention, my lord, fresh writ petition, my lords. Once against the rejection of the renewal of NOC, my lord, for taking admission and for different courses, my lords. Petitioner is an institution, my lords.
Rejection of NOC, what can be?
My lords,
Give your slip.
also earlier this honorable court has
Yes.
May I pardon?
Pardon to mention, my lord.
Yes.
An election petition not adopted to any bench, my lord.
Election petitions are being allotted. Please don't make a mention. All the matters are being allotted.
I may be pardoned to mention, my lord. I am bringing an humble accommodation, my lord.
Because I'm not well. Item number 5 has been listed. It's of the year 2005, I know. But I'm suffering from serious urinary infection. I'm not be able to. Today, at least 1 week after.
To be here when the matter is called, we will let him know.
Okay.
I may be pardoned, my lord.
No, definitely. 1 week after it may be
All right.
called. 1 week after I will be.
All right.
I may be
I may
pardoned.
be pardoned, my lord. I am through VC, my lord.
Just a minute.
My lord,
Just please wait for a while.
I may be-
Party, please. Yes.
Maybe pardon, Lordship, item number 10 of the list, Lordship. I'm conscious that I'm mentioning this matter on behalf of the counsel appearing for the opposite party. My learned senior, Mr. S.N. Mahapatra's wife is not well. He's taking the hospital. He requested my learned senior to take an adjournment.
Just see how embarrassing is that for us. All right. Whether the matter here adjourned.
And last time it was there, it was passed over. So Lordship directed the matter to be listed this week,
And
Lordship.
every time you are seeking adjournment.
1/8/2024, it was listed. My lord. Somebody asked for pass over, so we adjourned to this.
All right, be here when the matter is called.
my lord, I may be pardoned, my lord. I may be pardoned, my lord. I am through VC, my lords. My lords, I am bringing a humble accommodation. My lord, in writ appeal number 511 of 2024, the matter was taken up by my lords on 17th May 2024. But technically, the respondent, my employer, took an adjournment, and the matter was deferred to 24/6/2024, on which date the matter could not be taken up. But in the meantime, while the matter of lease regarding appointment of banking assistant promotional post is sub judice, now my employer is going to finalize the matter. So it is a very urgent matter. Pray for.
Which item?
My lord, it is not in the list, my lord.
No, give us.
Lord, I am through VC, my lord. 511, writ appeal number 511 of
Sir,
2020.
will you not give your slip?
Yes, my lord. My lord.
Give that.
Yes, my lord. My lord. Deeply obliged.
Item number 1.
Item number 1, your lordship, is infructuous. The awarded amount has already been paid to the opposite.
All right.
So grateful.
Petitioner states that his application has become infructuous. Okay. Review. Application expense disposed of accordingly.
Item number 2.
May I please answer? This matter, which is that court of wards, where the authority who had decided the original is not the authority to decide. The appellate authority is also not the authority to decide the appeal. I've given that notes. If your lordships, just to recapitulate your lordships,
Yes.
on this issue, below, the entire property was attached to court of wards. Now, I'm not taking your lordships to merits. If it's only a question of jurisdiction to decide. there are a lot of civil suits among the parties which said that it is partible. But the matter came to High Court. But High Court had an instance of the contesting OP number 4. And the High Court decided that the matter may go back to the appropriate authority. And the appropriate authority may also decide the parties. Now the matter was put before the Tehsildar. That the Tehsildar, under the circumstances, would be construed possibly as the manager of the property, not the Court of Wards, not the collector. So he decided the interested rights and said that it is partible. Then the opinion number 4, who is contesting, said that no, it is law of primogeniture is applicable and it is not partible. He filed an appeal before the ADM, and the ADM reversed the findings, which is before your lordships. Now, a question which had posed by your lordships to us, or to me, my lord, when I was arguing that whether the authority, who is the authority to decide? The Court of Wards. If your lordship has that statute, Court of Wards Act. I think last time your lordship saw. Yes. Yeah, last time I saw it was there. Court of Wards Act. It's there in the Odisha laws.
Volume 3 was
Volume 3.
Volume 3.
Or there is a new one. So maybe.
Volume 3 of that book.
No, it's an old.
I have annexed to my note also.
Yeah,
On the other
not
day,
to see
I
the
was
statute
referring-
because the entire act. I'm just putting the legal, the statutory provisions so that your lordship can decide about the person who is entitled to decide. That's being this. Lordship may see the Court of Wards Act 940. My lord, has got. The 4 is the definition. In this, if a lordship says A, the court means the Court of Wards. Court, it means the Court of Wards. There's 4A. Then your lordship says ward. Ward means a person who is under the charge of the court. That means if a person is in charge or whose property in such charge. So when I as a contesting co-partner says that my property is also, he said to my exclusion. Then the lordship kindly see, my lord, 5, section 5.
Yes.
The revenue commissioner shall be the Court of Wards for the areas for which the Act extends. Revenue commissioner. Revenue commissioner would be the revenue divisional commissioner because he is an authority above the collector. Your lordship sees 9. I mean, all orders or proceedings of the collector, other persons shall be subject to supervision control of the court. Court, my lord, here means the Court of the Wards. And he can modify reverse. Nowhere, my lord, the court here refers to the courts of the normal civil courts, but the Court of Wards, section 9. Now your lordship comes to dispute resolution. That's 58.
Section?
Sir, 58, section 58. Yes. When any question arises as between 2 or more wards of such a that an adjudication upon it by civil court is expedient, it shall be lawful for the Court of Wards acting to the collector of district case might have been stated for the opinion of the civil court. He can decide with the opinion of the civil court. Obviously, he can decide without the opinion of the civil court if he feels not necessary. Yes. Whether he would seek an opinion of the civil court or not seek an opinion of civil court depends on the authority that is the Court of Wards. And the lordships also may refer to appointment of managers, that is 26.
Yes.
So if your lordship would be pleased to see, there's something concept of appointment of managers, and the court may appoint managers of the property and guardians of the person, then the management and the guardianship shall continue under man. And the entire power is, my lord, vested with the court of wards for deciding, for vesting the property under the manager, for taking of property regulations. And your lordship, so far as release is concerned, to the person concerned is 59.
No, but in this case, what has happened?
Sir, in this case, what has happened, sir, when the property was attached under the court of wards, the property remained under the control of the, and I'm not going to merits of interested parties in civil courts, that's a different. It remained with the tehsildar. It remained and continued to remain under the tehsildar for a long time. Then OP number 4 came to this High Court and said that the property has remained so long and it may be returned. We are also a party in those proceedings. And the court said that, yes, at that stage, my lord, in the High Court, by an amendment, they raised the issue that it should not be released to all, it should be released to me on the basis of law of primogeniture. Then the High Court said, let it be decided by the appropriate authority about the respective rights of, it's only because of a decision to return. The appropriate authority of the High Court, of course, it missed out for parties also. They did not point out probably. And the tehsildar, who is not competent under this act to
No,
decide.
I am thinking on a different line altogether.
Sir,
That the dispute has not been decided by an appropriate authority. Therefore, it cannot be said that the dispute has been decided.
No.
The dispute is yet to be decided
yes,
by the appropriate authority, that is Court of Wards.
yes,
So what the Tahsildar has done, you can say it's his opinion.
yes,
The ADM, someone filed an appeal, that is his opinion.
yes, sir.
But finally, the Court of Wards has to decide.
Yes,
So whether the parties, instead of coming to this court, could have gone to,
could have, there is no further revision on the Court of Wards.
no question of revision.
Yes, my lord, what I'm saying that parties, yes, but true, my lord, but the only thing that party need not go because the authority has to decide because of the order of the High Court. The appropriate authority is to decide.
We understand. In fact, what
your lordships could possibly do, subject to your lordships acceptance, that this matter has been decided by the tehsildar, which, as your lordship says, could be a matter of only opinion.
Yes.
The ADM has decided in an appeal, which also could be a matter of opinion. Ultimately, the authority will decide the Court of Wards as per the direction of the High Court. The matter was to be decided by the appropriate authority, and the appropriate authority in this case was Court of Wards. Nobody was necessary. It was not necessary to file an application before any authority. So the court, in the meantime, may decide. The matter may go back to the Court of Wards, all the papers be placed, and let him decide.
No, but the Court of Wards will decide how.
Because of the decision of the direction.
Approach.
Direction of the High Court.
No, direction of the High Court.
The appropriate authority shall decide.
All right. But now, any person, see, the High Court said that appropriate authorities will decide. Tahsildar decided, ADM decided.
Which
any of the parties now can go to the Court of Wards that see these are the decisions are finally used.
The lordships can also do that. That can also be possible. One is that two alternatives, sir. One alternative is that the lordship can decide that since the matter has taken so long.
The first alternative is, the first thing is that we can say that the Tahsildar did not have the jurisdiction to adjudicate upon the interstate rights.
Because you are the manager.
ADM
obviously
did not have the jurisdiction.
Yes.
The court, therefore,
the jurisdiction is the Court of Wards.
lies with the Court of Wards.
Who is the Revenue Divisional Commissioner?
Your lordship may kindly have a glance.
And the second is that we quash both the things.
Yes.
And we may, so these are two things.
So what I humbly submit to your lordship, because the process, it's has taken. Nobody is to be blamed for that. Oh, the process has taken, say, more than 4 or 5 decades now by now. So instead of Lordship can decide directly, because the High Court has already directed to decide by the appropriate authority, that your Lordship see the direction. So this direction only your Lordships are coming to the conclusion that the person who has decided is not the appropriate authority. That if Lordship see the direction of the High Court, the High Court did not say that the parties may approach the appropriate authority, but the appropriate authority, because the responsibility of taking is their decision to take is theirs. So I'll just one more only. The decision to take is theirs.
Please come to subsection 5 of subsection 2 of section 5.
Subsection.
It says court and competent courts.
Lord, section 5.
Subsection 2 of section 5.
Take written charge of which may place in charge by order of a competent court in accordance with the provisions of the court. May deal with every person and every property of which it may take or retain charge or may be placed under its charge by order of a competent court in accordance with the provision of court. But this act, I'm subject to your Lordships, this act came into force in 1947. But the property was taken prior to that, under the Bengal Act. So if the Court of Wards takes any property under this act, he may require certain certification of the competent civil court, taking of the property. That means taking to his control.
This competent court is competent civil court.
The court will deal with the person with charge with competent court in accordance with the provision. The court may deal. Competent court would be considered to be civil court first. Here. Civil court will be here, but that contingency doesn't arise. This is only when you take the property. Property is taken long back, prior to statute. You'll also see that the Revenue Commission shall be the court of wards. The court shall deal every person property of his merit and charge or which may place in charge or order in charge by order of a competent court in accordance with the provision. It could be, either way. So, but one more thing, so
the Court of Wards can be approached by the parties also.
yes,
for determination.
It cannot be, their power to approach it cannot be denuded. But what I'm saying to them, my lord, this is a very peculiar in the sense the Court of Wards decides to take the property, decides to give it back. Here, my lord, the responsibility or the authority to take is theirs. The responsibility of giving back is also theirs. There is no actual procedure by which you apply to the Court of Wards because they take it, my lord, as your lordship knows, and the Court of Wards could be considered like a receiver. That means he is in charge of the property because of certain mismanagement or whatever contingencies we are not concerned at present, and take the property and in appropriate time give it back.
Therefore,
parties can always approach, my lord.
Therefore, we are saying that it's a different matter that you came to the High Court.
Yes, I came to High Court again. He came.
This time you came to
the last time he came to the High Court.
Last time he came
to the High Court, and the High Court said, yeah, appropriate authority to decide. So what are falling from
Had
your
he-
lordships?
Had he not come to the High Court and he would have approached to the Court of Wards,
That's also possible. Possible. Possible.
and
Yes,
that would
lordships.
have been possibly the correct.
I mean, parties have possibly not taken all the possible rights for probably whatever reasons. Whatever reasons. I mean, that's for your lordship to whether your lordship will give the right to the court authority, because the court has always, you decide, giving opportunity to all. There's two things your lordship sees in the High Court order. High Court order, yeah. Okay, chief order. Huh?
Yes.
Yes, but there is, it's not the because collector has certain also role, but on place 173, parties have approached the collector. Page 173 of the brief, and your lordship sees page 172.
Page 172 is the order.
171 High Court order. Because we are going by the High Court order now, because the lordship can go back to 171 first. The disposal of the direction. If your lordship got that, page 171. After a few lines, the learned additional standing counsel appearing for the state also state that the state has already decided to release the entire lands which are under the management of Court of Wards in favor of the rightful claimant. In this view of the matter, we dispose of the writ application with the direction that the appropriate authorities to consider the petitioner's claim as well as that of opposition number 11. I was for the opposition number 11. By giving them opportunity to produce relevant materials in support of their respective stands, and thereupon shall decide as to who or all of them are entitled to take in the management and possession of lands which are now in possession of the Court of Wards. Lordship says, it is stated by the council that some amount is lying, that we are not concerned with. The amount shall be paid to the person who will be held entitled to get back. The appropriate authority is called upon to give opportunity of hearing them. But three things the court directed, that they said that we want to return. Then the matter said that the lordship says the direction approved to consider the petitioner claim as well as the opposite from 11. So what, my lord, I mean, I don't want to prejudice anything this, but what I'm telling you, lordship, there's a great propensity nowadays to relegate matters to the inferior persons. I mean, inferior, like if a collector is to decide, collector will send it to the tahsildar, somebody, so that they don't take the responsibility of the matter. But be that as it may, my lord, this is that. There are two options, my lord, now. The authority was decided is admittedly not the authority. The authority who decided the appeal is not admittedly the authority. There is already a direction. Whether your lordship will direct the Court of Wards being the appropriate authority to decide, or your lordship say that parties may approach and they can comply with this High Court's order and decide. That's for your lordships to discuss. That is, and all facts of relating to civil suits and other things are notes, but in not merits, since your lordship are not going to merits. So and he has, in fact, in the morning.
So we too have the tendency of.
Sorry?
We too have the tendency of shifting the burden of
No, my lord. My lord, I'm sorry, my lord. No, I'm sorry. If your lordship may permit me one more indulgence. Once, my lord, I mean, Justice G.K. Mishra, former Chief Justice of this High Court, was sitting in his house. And incidentally, is related to me. That's a different issue, my lord. He was approached by a minister of the state for a card, for invitation card for the marriage. Then he said that, hello, Judge, how are you? The minister thought that he's mistaking me somebody else. He's saying me, Judge, I'm not Judge, I'm a minister. He said, no, sir, probably, sir, you have forgotten, I am such and such minister. He said, no, I'm saying you are a judge because High Court is always asking you to decide. So you have become a judge. That's, my lord, just like I remembered. So your lordship may decide this part, that part, and so far as a suggestion came to him from the morning.
See, here is a case where we cannot decide.
No, I'm not.
Even if-
I will not call. I mean,
Even if
after all
they are
this,
willing.
after all this, I will. After all this, I will also not tell your lordship that the ADM only didn't have the authority and the Tehsildar had. No, the Tehsildar didn't have, the ADM didn't have, and
No.
a suggestion came to your lordship. Could a line of observation would help? The suggestion came to him that since the parties and dispute, they could decide on conciliation, but the conciliation things will not happen there. Your lordship can indicate that it is for the authority to conciliate and
Explore the
decide,
possibility.
explore the possibility. I mean, it's not possible any further here because of so long and they're coming now. So lordship can also say that the appropriate authority that your lordship may decide either the parties, your lordship give the discretion to parties to approach, and they shall also abide by the earlier High Court order by giving opportunity to all concerned. That's the High Court order.
No, that is
there. That's so
Once
opportunity.
this was one, these two orders are set aside, the previous order of this for previous orders. So in that event, the party who had
No,
approached this rule
this time we will specifically direct
Who is
as
satisfied?
to who is the
Yes,
competent authority,
That is all.
how should the Court of Wards proceed,
right, ma'am.
through collector, civil court, what are
Yes.
the options.
Yes.
So
Yes.
these things should be clear this time.
And who will
I
approach
prepared
the
just a
authority
small-
also, ma'am.
I have prepared a small note. Okay.
Okay.
I have appended, this is the admitted genealogy quoted by everybody. First of all, I will take your lordship to the genealogy.
No, that
Only-
is not the question.
I will satisfy your lordship's question whether the order passed by the appellate authority is
No,
justified or not.
Then you
Whether the appellate court had got the jurisdiction to pass the order or not. If I can satisfy your lordship that the appellate authority had got the jurisdiction and he has rightly passed the order, then the question of other things do not arise. For that purpose only,
For that, before you go to that, you will have to satisfy the court
right,
that Tahsildar had the jurisdiction to pass an order. Because ADM has not passed the order, the original authority.
right,
He has passed the order as an appellate authority.
my lord.
So whether the Tahsildar had the jurisdiction or not.
My lord, the order passed by the ADM may be treated as the original authority. And the statute has taken care of under section 8 and 9. 8 provides any order passed by the ADM or the collector appeals to the court. Court means the Revenue Divisional Commissioner. Then the appeal has to, if my learned friend is aggrieved by the order of the ADM, he can prefer an appeal before the RDC. The Court of Wards Act provides for that. Apart from everything, if anybody is aggrieved by any order, then they can approach the commission,
You are referring to section 8.
section 8 and 9.
It says an appeal, but I hope this is the up to date.
My lord. An appeal shall lie from every order passed by this act by the collector of the court.
Not of the
Here-
court, to the court.
To the court.
Yes,
To the court.
to the
The
court.
order, the collector ADM includes the ADM. If
To
the,
the
if
court,
the, sorry,
to the court,
to the court, court has been defined
yes.
under
In the
2A, 4A,
Court of Wards.
Court of Wards.
Yes.
Court of Wards has been defined, Revenue Commissioner, the RDC,
Yes,
shall be the Court of Wards for the areas which is this act extends. Therefore, if my learned friend is aggrieved by or the order passed by the ADM or the collector, the provision of appeal is there under section 8, that is a statutory provision. That apart, section 9, control of court. All orders or proceeding of the collector or other person as aforesaid under this act shall be subject to the provisions and control of the court, and the court may, if fit.
See, if you are reading section 8, you will have to read section 7 also.
Right.
that I will take your lordship to section 7.
Section 7.
The power of the court, how exercise? The court may exercise all or any of the power conferred on it by this act through the collector of the district.
Collector of the district.
My lord.
So ADM is not the collector of the district.
My lord, the ADM includes the collector.
No, it is clear. The expression is very clear. It is not that ADM, additional collector includes collector. It says collector of the district. It does not say ADM or additional collector. And in that background, see what section 7 says, that the court may exercise all or any of his powers conferred by this act through the collector.
My lord.
So it can exercise all the powers through the collector of the district within the limits, and then may confer any of the powers on any such collector or person and withdraw any powers so conferred. This is one. And then it says that in that case, an appeal shall lie from every order passed under this act by the collector to the court.
To the court.
So the collector can exercise powers only under section 7.
Section 7.
So section 7 order will be applicable.
My lord, on the other day, I was taking your lordship to the provisions of the administration of state order 1948, that is in volume 1. There, in the administration of Orissa state order, the state government decided the provisions of the Court of Words shall also be governed under the provision of the administration of Orissa state order, and section 2C, 6C provides that an appeal against the order of the subordinate officer, sub-collector or subordinate, lies to the collector or ADM. There the collector has been defined.
They might have seen, Mr. There is different. Collector might have been defined as additional collector.
My lord.
Collector would include additional collectors. But when it says collector of the district, there is difference between collector and collector of the district. Can you say that additional collector is collector of the district?
That has been defined in this administration of Orissa state.
Let us see.
Clause 6, explanation. 6C. And revenue jurisdiction, 6. C is relevant for the purpose. An appeal shall lie from an order, judgment, or decree of subdivisional officer or other specially empowered under subparagraph B to the collector, who may either hear the appeal himself or transfer it to an additional collector or to any revenue officer subordinate to the collector and especially empowered by the commissioner to hear the revenue appeals. The collector may withdraw to his file any appeal or transfer. Explanation. This is important. Expression collector and additional collector shall respectively mean district magistrate and additional district magistrate of the district constituted under the provision of the Code of Criminal Procedure 1898. In PC, collector has been defined. It includes the additional district magistrate. And on the other day, your lordship wanted to know whether there is the Court of Words has been mentioned in this administration of Orissa state order or not. It has been mentioned. Your lordship, in the schedule 2 starts at page 74 of that book. Page 74. Serial number 1 to 83 are the central acts to which the administration of Orissa state order is applicable. Your lordship may mark schedule 2 central acts. Central acts has been mentioned from serial number 1 to up to page 84 sorry, it is up to page 88. Thereafter, after 101 serial, then the Provincial Act of Bengal, because Odisha previously was within the state of Bengal. Therefore, all these legislation passed by the 1, 2, 3, 4 legislation passed by the Bengal Act. Thereafter, Bihar and Odisha Act, you also mentioned at page 88 of the book. These Bihar and Odisha Act, which has been passed by Bihar State Assembly, the name of the act has been mentioned. And lastly, at page 91, the act which was enacted by the Odisha Legislative Assembly has been mentioned at page 91. There it has been mentioned at page at page 94, the Odisha Court of Words Act 1947, Odisha Act of 1947. To take the immunity of the after post independence, this order was passed by the Odisha Assembly, taking the preventive care if there is no provision in any other statute to regulate regarding appeal or revision, anything else. Therefore, this order has been passed, and there are any number of judgments by this Honorable Court that the Odisha administration of state order shall apply to the revenue jurisdiction within the state of Odisha, including the present Gangpur state.
Is this your submission
My lord,
that because of this order,
my lord.
the jurisdiction? No.
No, my humble submission
Just-
before
just-
Lordship,
just step by
Tahsildar,
step by step. This is you cannot submit that Tahsildar had the jurisdiction because of this order.
Tahsildar has no jury.
No jurisdiction. This is
Right.
unadmitted.
Right.
Now, according to you, the ADM has exercised the power.
Obliged.
He is the additional collector, and therefore, under the
Administration of state order,
he is the collector.
collected.
He
And-
is the
and-
collector of the district.
My lord.
Can you on the basis of this say, and that is only for the, just see which 67.
My lord.
See the language. Language is very clear.
An appeal shall lie.
And this expression collector
Right.
will depend on statute to the provisions under the statute, particular statute. If statute specifically provides that circle officer shall be collector for the purpose of the act, circle officer can be collector.
Right.
So, but he is not the collector of the district. The hierarchy as contemplated under the Court of Ords Act is different. This is our tentative view.
My humble submission before Lordship is taking into all such peculiarity of the provision,
Now,
the
you
Odisha
were reading-
Legislative
just a
Assembly
minute,
passed the order.
Just a minute.
Obliged.
You were reading explanation,
Explanation.
page 67.
67.
Read it again.
The expression collector and additional collector shall respectively mean the district magistrate and additional district magistrate of the district constituted under the provision of the Code of Criminal Procedure 1898 as applied to the Odisha states.
It has no meaning at all except that
The
the collector will mean district magistrate and additional collector will mean additional district magistrate. It does not say that
And-
the collector will include additional collector.
In addition to that, to your Lordship, my humble submission of your Lordship is whatever collect has been defined under the Code of Criminal Procedure 1898, that is also the definition of the collector.
All right.
Magistrate of the district constituted under the provision of the Code of Criminal Procedure 1998, and there under the CRPC, collector includes the additional collector. Or ADF. That is my humble submission of your Lordship. Therefore, my humble submission
So
of
let
your
us see the CRPC also. Because
Sir.
we don't think this expression additional collector is there under the CRPC. Let us.
Sorry.
All right, let us decide. We'll decide. So please give your this thing. Please help us by providing the statutory provisions.
Yes.
Bunch of statutory provisions.
Your Lordship may close it, I'll submit it, or your Lordship may complete for.
Let him
dictation.
complete first. Let him complete. If he has
my-
to say anything.
My lord, then I will take your lordship to the impugned order now. What is the order passed? That is at page, relevant portion only, I will take the last page.
Mhm.
Page 210.
See, the question is if a correct thing is decided correctly by an incompetent authority, that will
No,
not become correct.
No. What ADM suggests, let a decision be taken under section 59. The impugned order, which is being challenged by my learned friend, last paragraph of page 210. Section 59 of the Court of Arts Act 1947 prescribes that the court may, with previous sanction of the provincial government, in all cases where superintendence has been assumed in presence of order under section 16 and 17, at any time release from its superintendence to the persons of property of a ward or both, and shall have, as provided in section 62, relates from the superintendence. Hence, release of the state will require sanction of the provincial government. The Tahsildar Biramitrapur, who is now manager of Court of Wards, shall move for sanction of the state government for release of the state from the Court of Wards in favor of the appellant. The ultimately on section 59, the court may decide, no, it is not the appellant, it is the respondent number 1, 2, or 3. The ultimate order is the appellate authority passed an order. My order is not final. The provincial government's order, that means here the order of the Revenue Divisional Commissioner shall be sought for by the Tahsildar and he will take a decision. He may take a different decision.
No, but that power vested with the Court of Wards.
Section 59. Yes, my lord.
Please read 59.
Without time, the property cannot be released, even if the original authority passed some order or appellate authority passed some order.
Original authority, that is not the question. The question is that he did not have the jurisdiction to decide.
Right. Absolutely right.
How can he exercise power under 59?
Even if that order is illegal, even if I will not go for an appeal, then that order will stand. Ultimately, the property would have been released in their favor. Therefore, I take resort to the provision of 1948 order and I file the appeal. If I would not, suppose I would not have preferred an appeal because the order is erroneous or illegal order, they could have taken the property. Therefore, taking into the situation.
Both of you committed mistakes. Both of you ought to have raised this, taken this plea before the Tahsildar. Let's see, you don't have the jurisdiction.
The very eminent lawyers, Barrister Ranjit Mathi was representing my client. While the previous writ application was disposed of my Lord Justice G.B. Patnaik and I presiding a division.
There is no, in the order passed by this, it has appropriately been mentioned that
it is appropriate authority. As per the direction of the collector, the Tahsildar initiated the proceeding and they represented through their local lawyers there. They did not raise any objection.
They means we. We did not raise any objection.
And because it
appearing for both the parties. And even before the appellate court, if my learned friend would have raised a point, no, under this statute, you are not the competent authority to hear the appeal, then the matter could have been otherwise. They would have come to this honorable court, the matter would have been settled. It is a dispute. It is a dispute Your Lordship will visualize. My father was the court of wards.
We can visualize everything.
No,
We
my
do
lord,
visualize.
only one sentence. My father was the court of wards, Harposdar, in the year 1940.
Your
The
father was
property
father
taken
was not
from my
court of
father.
wards. Your father was not court of wards.
Not the court of law. Court of law.
No. My father was the Harposdar, whose
Harposdar.
property was taken over by the court of wards, and I am his only son. Others are their brothers, sons. As a member of junior family members, they have already received their maintenance.
Why are you going on to this fact?
No,
All these are necessary
Then your Lordship.
because this is the.
Title suit said there, he is not saying so.
And I am saying because I brought this provision under section 58 when you produced before this honorable court, there was a civil suit. Civil suit is a bar. Section 52 provides under the Court of Wards Act, civil suit is a bar. Therefore, I brought to the notice of this honorable court section 58. If there is any dispute arise between the wards, they are not the member of wards. If at all, I may be the wards because I am the son of the ward who died in 1955.
Mr. Our limitation is that we are bound by the statutory provisions. law. So whatever they say, they dictate us. The statutory provisions dictate us. So we will follow what is there.
Oblige your lordship, I have submitted
Just
my written note.
Written notes, we will look into that. And for our convenience, just
I'll give an additional note, only the legal provisions.
only legal provisions.
Only the
give
legal
us the legal provisions. So give the legal provisions
Legal
separately.
Oh,
So that it may be
3-4 days time may be required to prepare it.
3-4 days time.
Monday,
In fact, if we dictate the order in the courtroom, that will be more convenient.
As your Lordship.
So that you may
Yes,
also point
yes.
out whether we are,
Yes.
where are we committing mistakes.
Possibly your Lordship can give it to day after tomorrow.
They are not day after tomorrow.
maybe Thursday.
Day after tomorrow,
Saturday
we
we are not
are not sitting.
As your Lordship. Any date within this week,
Monday,
any date.
can
Not
it
only-
be Tuesday?
Tuesday.
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 There should be
No, Thursday.
Yes, there should
It will
be.
come on Thursday because all
All matters are being listed on Thursday.
Oblige on Thursday.
Oh, Thursday is 15th.
Thursday
Let
is
it come on
holiday.
22nd. Let it come on 22nd. In the meanwhile, you will
In
have
the first
enough,
5 cases or
enough
something.
time, as precise as you may
Yes,
be.
we will.
See, the
It
judgment should not be more than 5-6 pages.
could be, yes.
All right. We have just to deal with the
Right.
statutory provisions.
Yes. But I did not argue anything else except it's not necessary. Your Lordships have already taken the entire gamut of the case. One is, my Lord, sections, just your Lordship can take a mental note of it. 6, which it says appeal. You have a power. 6 is revenue administration of the state. 6, heading. And the 6 says that the revenue administration of the state, which is done by erstwhile, shall be done. The RDC is the head. Sub-collector shall pass an order, then there is an appeal. These are not revenue administrations of the state to start. Second, my Lord, he is relying that he has already passed an order. He is not a final authority as given to the state government. No. The 59 speaks, if the Court of Wards decides finally, he will refer it to the state government, not the, that is to, I will give your Lordships the,
You are reading partly.
no.
Subdivisional officer or any other officers. That is there. Therefore, I have brought to the notice of this honorable court 1948 order. 1948 order has taken care of all the acts.
Not relevant at all.
We will see. And if you give us the your submissions and the statutory provisions separately.
Submissions are already on
The
record.
entire book.
Sorry, factual
entire-
submissions are on record. Factual submissions, both sides on record. The statutory provision, since a new thing is emerged, we'll give it separate.
Factual positions, we may not go into
Yes,
all those.
that's there. It's all on record only.
And one
We'll
more
give
thing was under special statutes. Once it is not mentioned that district master collector means he is not like not under the Essential Commodities Act. Not confiscation proceedings shall be initiated by the district magistrate. Means only district magistrate. It cannot be not delegated to the ADM.
Particularly see, there are provisions where the collector is defined. Collector means collector of the district
Right.
or any other specifically notified
And state
required by the state government, then that if circle officer, if sub-regional officer, if block development officer, any officer is designated collector, he becomes the collector. But when it is clear that collector of the district means the collector must be of the district. So that is
In some other statute, like OLR Act, Orissa Land Reforms Act,
Maybe excuse
the collector includes the additional district.
Maybe
You're absolutely right.
Provided specifically under
This
that
is
act.
this is what we are saying.
This one which was listed, we had asked to inform Mr. Kaurav.
Quorum, I tried to get him notes over phone, but I think he did not receive my call notes. Maybe the
This is the second consecutive day when there is no representation on behalf of the petitioners. First of all, earlier the last time the matter was taken up earlier on 2024 when there was no representation on behalf of the petitioners. Most of this application is accordingly dismissed for non-prosecution.
Yes, I was present on behalf of the people.
Both the ministers, both the ministers. Ministers further on behalf of.
Item number 5.
Appearance will not respect. No. Others.
Mr. AK, sir, 2, 3, 4.
Which item?
Item 5.
After my learning senior mention for us.
5, all right. As requested on behalf of the petitioner, list this matter on 22nd.
Item number 6.
Item number 6, Lordship, on behalf of Senior Advocate R.K. Mahathir, no instruction.
CMS, no instructions.
Item number 7.
Madam, file the notices within a week. Within a week, I'll file the notices, madam. It has not been filed, and the defect which has been pointed out, that also I'll remove it.
FA is of 2000. The first appeal is of 2000.
Sorry, madam, that is not mine, madam. Sorry, madam.
Item number 7.
Sorry, madam, that is not mine. Sorry.
CMAPL 60 of 2007.
CMAPL, yes, madam. CMAPL is mine. That is that I do not know what is that disposed of appeal has been tagged to that.
It is not tagged to it.
Yes, madam, that appeal, it has mentioned that it is disposed of case.
FA is disposed of.
Yes, the CMAPL, I am praying for the notice to be given within a week. I'll file the notices.
You did not file Requisite
Years.
My lord.
for last 17 years.
My lord,
Why-
inadvertently it has not been filed, my lord.
What is the matter about?
But that also, actually, the
That also-
brief, actually, the brief has been misplaced somewhere. I pray, that crowd I am praying for them.
No, not the way.
No, but Mr. Das,
Yes, madam.
the appeal was dismissed because the registry reported that the notice was sent to the appellant for engagement of lawyer,
Yes,
but after valid service of notice, they did not engage.
my lord.
So that is why the appeal was dismissed, which was defective was dismissed.
My lord. But thereafter,
In fact, the appeal, that means defects had not been removed in the appeal also. But the court thought it fit to issue notice to the appellant, which is the bank.
my lord.
But since nobody appeared, thereafter it has been dismissed. So because you don't have the file means, I don't think there is there.
Actually,
We
the
don't have-
CMFPL file, appeal file, CMFPL file was with me. It has been misplaced somewhere. That's why I'm praying. I have not seen that side.
When the CMFPL file is there with you, then why didn't you take issues of notice?
Yes, ma'am. That inadvertently it has not been taken.
The advertence for 17 years. Yeah, you should not. The present application has been filed for restoration of FA number.
Yes.
237 of 2010, 2000, which stood dismissed for default for non-prosecution on 28/11/2006. So, stop. This restoration application came to be filed in 2007. The by an order dated 3/5/2018, this court had directed for issuance of notice to the opposite party.
Yes.
To the opposite party, the steps for which they are required to be taken. Taken within a week. Stop. Till date, the petitioner did not comply with the said order dated 3/5/2018 as the requisites could not be filed. Stop. Next. Considering the till date, the requisites have not been filed. So, considering the conduct of the petitioner, we are not inclined to keep the matter pending. So, the application is accordingly dismissed.
Item number 8.
My lord, I have made ready the amendment petition to delete that portion of ultra virus. Not to declare the ultra virus. Let it come next week, my lord. I will file the amendment petition register.
I will request on behalf of the petitioner on this matter on 22nd.
My lord, 2 weeks for objection. It is state, my lord. I have challenged the ultra virus. State is to give objection. It is for. I'm the liquidator. I'm the OP number 1. I'm the main OP. I'm the main OP number 1.
So you want
Liquidator.
him to, you want him to pursue his challenge to
No, I'm not gone through the petition. So,
go through the petition? How much time will it take?
at 2 weeks time.
Therefore, we are adjourning it to 22nd.
My lord. As your lordship. As your lordship.
Item number 9.
My lord, on last topic, my lord, I asked us to take instruction with respect to the lot 1 property, my lord. It's some time, my lord, 1 week time, my lord, because it's a old matter, so we are doing little bit of such, my lord. If we take it up this week or
What is this matter about? Let us recapitulate.
my lord, OSFC is for the petitioner, my lord. I am for the Orissa State Financial Corporation. Here, my lord, his allegation was that lot number 1 property was sold undervalued. It was sold in sale, my lord, it was for sale, sold for 12 lakhs, but transfer date shows that it is only for 6 lakhs. So my lord has asked.
Yes. Then what instruction do you?
My lord, I'll take instruction because whether it is transfer deed is with entire lot, my lord, is inclusive of land, building, plant and machineries, my lord. So transfer deed is with regard to land and building, my lord. Whether the machineries has been sold for another 6 lakhs, that's my lord instruction I will take.
As requested on behalf of the respondent, opposite party. This matter on 22nd.
Item number 10.
Item number 10, lordship, I'm mentioning.
I'm on behalf of Mr. Mahapatra, my lord. He has some difficulty. He has also not come.
She's asking time on
Yes,
his
yes,
behalf.
I have known this.
This is matter on 22nd.
Item number 11.
We make it clear that no further adjournments shall be granted.
Okay.
As the matter is pending for last 15 years, last 15 years.
Item number 11.
This heat application has been filed. I am for opinion number 2. This is the application has been filed for violation of the town planning provisions by
Which town?
Pardon, my lord?
Which town?
Raulkela Development Authority. It has taken step back because it has made constructions in violation of the approved plan. Thereafter, matter went to the Appellate Authority under Development Authority Act. Appellate Authority remanded the matter. So they have challenged this.
You are for the petitioner.
No, I am for the Development Authority. What I say, my lord, one technical point. Here, my lord, matter is to thus when after the Appellate Authority remanded the matter to the development of the step while the matter was pending, has challenged that in the CT application. In the meantime, from 31st August 2019, the power of town planning has been transferred from development authorities to municipal authorities. In this case, to the Raulkela Municipal Corporation. Even if this application will be dismissed, then also I can't implement the order because I don't have the town planning power. It has to go to the Raulkela Municipal Corporation. So my humble assumption is either this will become infructuous or he may amend it to implement Raulkela Municipal Corporation as a party, so that it can be effectively adjudicated.
Your Lordship, giving deputy consumption subsist, I will again approach this court.
When counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this writ application with her liberty and to approach this court again if further of action survives in the changed circumstances.
I am for opinion number 2, DK Mahapatra.
Item number 12.
Item 12, may I please, Your Lordship? Yeah. Due to appeal mailers,
Friend starts, my lord. Only I pray, my lord, 2 weeks time so that I can file the counter affidavit because this matter was resolved subsequently in 2022 and later one order was also recalled in 2023.
Item 12.
12, my lord. I think notice also not issued. Notice also
notice also has not been issued. The writ appeal mailers notice has not been issued as yet, mailers.
No, this is a writ petition.
Writ petition.
A writ petition. I'm sorry.
You are for
I'm sorry. It is against the order of the learned tribunal, which is at page 49, mailers, annexed 12.
You are for the petitioner.
Yes, sir. Because the original application filed by the petitioner before the learned tribunal, that was dismissed by the learned tribunal on the basis of the findings, which is under challenge, mailers.
And dismissed by this court.
Yes.
And dismissed by this court in 2015. Thereafter,
Yes, it was dismissed for non-prosecution in 2015. Thereafter, it's a transfer with mailers. Thereafter, I filed a petition and that was order was recalled, mailer.
So what is wrong with the order? The tribunal.
Wrong, mailers,
They
Your
pass
Lordship.
correct orders.
The findings arrived at page 52. Page 52, mailers. Page 52, that the findings arrived at by the learned tribunal that the petitioner was appointed years of the rule. That is not at all correct, mailers. Till that, no statutory rule has been framed. He was engaged, he was appointed on ad hoc basis. And the other mailers findings that the learned tribunal has arrived, that it is.
So you had filed, you claimed regularization.
Yes, yes, ma'am.
That has been turned down.
Turned down by the tribunal.
So what is your
Wrong, mailers, page 52, LRC.
Page 52, we are there.
Yes, last paragraph, mailers. Considering the submission, the Learned State Council submitted that his initial appointment was years of the rule.
Yes.
That is not correct, mailers. Because
In accordance with the rule.
there is no rule as on date, mailers.
Huh?
Even till date, no statutory rule has been framed by the government.
Therefore, anyone can be appointed.
No, that is not my submission, mailers. Because Lordship may say that your Lordship will find that initially he was appointed on ad hoc basis. 89 days basis, that spell continued from time to time. Then he approached the learned tribunal seeking regularization, mailers. The learned tribunal, mailers.
Sir, what right did you have
Yes.
To be regularized.
Because he continued, he has the qualification and there was against the existing vacant post, he was allowed to continue. Against the vacant post mailers. He was allowed to continue. Not only these petitioner mailers, many others mailers. Many others were allowed to continue against the sanctioned vacant
And
post.
see, so clearly the tribunal has mentioned that you continued because of the orders passed by the tribunal.
Yes, I'm coming mailers. I'm coming to that mailers. That is also not correct in view of the fact that when he approached the learned travelers, while issuing the notice mailers, I have quoted the order. The learned tribunal, I have quoted the order in the body of the petition mailers. The learned tribunal protected my services. Thereafter, what happened, mailers? Immediately thereafter, the authority proceeded for initiated the process of recruitment, and the requisition was made. Was made, but in the requisition, mailers, two conditions that was against the mandate of the constitution. That was stipulated that the person must be from the particular district, and he must have studied in the Koraput district. So challenging this, because this petitioner mailers, he could not become eligible to apply, and he was continuing against the sanction post, and the process was started, and he was willing to compete along with others. So therefore, he petitioner again approached the learned tribunal, challenging those requisition mailers, and the state opposite parties mailers, they compared with the counter affidavit, saying that we have deleted those two conditions. Thereafter, the recruitment process.
So these are different aspects.
Yes.
One, you are claiming regularization.
Yes.
You are claiming regularization on the ground that you continued for quite a long time.
Long time against the vacant.
And on the other hand, in the recruitment process, you had challenged the recruitment process successfully. That they deleted the
two conditions.
But the fact remains that you continued in service because of an interim order passed by the tribunal.
Yes.
So the
judgment is not applicable. Yes, sir. It is not a case, my respectful assumption before
Since when you are working?
Mailers?
Since when you were working? What was your initial?
1992, mailers.
1992.
Yes.
Today is?
Mailers?
And we are in 2024, July 2000.
Yes.
You're working in 1992 and you filed the OA in 1994.
1992.
2 years you wanted regularization.
He represented the authority, thereafter approached the learned tribunal. He represented the authority, thereafter approached the learned tribunal.
We are not.
Mailers. So what has happened, mailers, my respectful submission that it is not a case that the petitioner the authority did not allow the petitioner to continue. They wanted the services of the petitioner. That is why they allowed the petitioner to continue. So while the learned tribunal issuing the notice in the matter of regularization, mailers, they protected my services. It is not a case that against the order of termination I had approached the learned tribunal. So the authority.
The fact remains that you continued under an order passed by the tribunal. So they could not have removed you.
That is a fact, mailers. But thereafter, mailers.
What was the order of the tribunal passed?
The learned tribunal was passed. I have put mailers in the body. 21/1/1994.
And from 21/1/1994, you continued till the dismissal.
No, mailers. What has happened, mailers? Subsequent development has also taken place. Even after the original application filed by the petitioner was dismissed by the learned tribunal, which is impugned, the authority also allowed me to continue.
Very good.
Allowed me to continue, and he continued in service. Mailers, thereafter, what happened, mailers, when the writ petition was dismissed for non-prosecution, and thereafter to that order, mailers, they have terminated my services. And challenging the termination order, I have filed another writ petition that is also pending, in which counter or rejoinder has also been filed. Because the petition was terminated, mailers, that is why no interim order was passed. So that is why, mailers. Terminated.
The petitioner has put to challenge an order passed by the Odisha Administrative Tribunal, bracketed Cuttack Bench, dated
Dated my lord.
2010.
10, my lord. Yes, sir.
2010. Passed in way number 178 bracketed C of 1994, whereby his original application came to be, no, original application was dismissed. Was stopped. The petitioner's case that he was appointed as fieldman demonstrator under Assistant Soil Conservation Officer Raigada with effect from 1992 and on ad hoc basis for a period of 89 days. Stop. The period was subsequently extended from time to time. He later applied for a regularization officer. Stop. Service and approached the tribunal by making the said original application. Stop. It appears that it is not in dispute that while issuing notice, the State Administrative Tribunal passed an interim order to the effect that, where is that?
Page 4 of my petition.
Page 4.
Yes, I have put it. Page 4 of the report.
Passed following order on 2021/1/1994. Page 46.
Again, another order was passed on.
Because they did not violate.
Later, the
They did not
order
honor the.
was passed on 3/3/1994 by the tribunal. Would be page 4. So, the petitioner thus continued on ad hoc basis on the strength of the interim passed by said interim orders passed by the tribunal till the tribunal dismissed the
Page 35 of the report.
till the tribunal
Beg apology, my lords. Page 35 of the petition, the another order passed by the learned tribunal during pendency of the previous OML. Page 35, my lords. Kindly have a glance. There the learned tribunal mallards, while disposing of the original application, the second one, directed the petitioner, the authorities to allow the petitioner to compete along with the others in the recruitment process. Page
So it is
36, madam.
also to be noted that during the pendency of the application before the State Administrative Tribunal, an advertisement was issued for filling up the post against which the petitioner.
Requisition was made from the employment exchange. Requisition was made.
Steps were taken being taken to fill up the post against which the petitioner was working.
Six numbers of post.
Through employment exchange. Stop. The petitioner had filed another application before the tribunal registered as OA 1594 of 1996.
Yes, this is before Bhubaneswar bench.
Before
Bhubaneswar bench.
No seat.
Yes.
Terminal bracketed Bhubaneswar bench. No seat. Bhubaneswar. So, in the said OA, an order was passed on 21/4/1999 by the tribunal as under since the appellant is in service as an ad hoc employee, his service shall not be terminated until regular appointment is made to the post. He shall be allowed to participate in the recruitment test, if any, for selection of candidates to fill up the post of fieldman demonstrator. His upper age limit may be relaxed in case he is found overaged by the time of holding the test, provided he was provided he was within the prescribed days limit when he first entered into his service. Unquote. Unquote. So, what happened to that?
They did not proceed. No recruitment. They did not proceed with the recruitment. They did not further proceed with it.
The tribunal, considering the circumstance that the petitioner had in fact continued to work on ad hoc basis on the strength of an interim order passed by the tribunal, relying on the Supreme Court's decision in case of Secretary of State of Karnataka versus Uma Devi, AIR 2006 SC 1806, dismissed the original application. So, just coming back. Application wherein the petitioner had sought for a direction to regularize his services on the regularize his services. Okay. And counsel appearing on behalf of the petitioner has submitted that even after the order passed, the impugned order passed by the tribunal, he was allowed to continue. So he has continue till the present writ application was dismissed for default. Allowed to continue. His services were terminated after the present writ application.
It was dismissed for default, my lords. Thereafter, on the basis of my petition, it was restored. Restored, the CMA appeal was allowed. Thereafter, the matter was listed before the Honorable Assigned Court, my lords. And because I had not filed the Wakalatnama in the writ petition, that is why the Honorable Court again dismissed that writ application, this writ application. Thereafter, I filed the Wakalatnama and that was recalled. That order was recalled.
So 2 times your writ petition was dismissed.
Because in the CMA appeal, I had filed the Wakalatnama.
We are not. See,
Yes.
this writ application was dismissed twice.
Yes, because my name was not there.
Forget name.
Yes.
So you have been disengaged when then? Because once in 2015 it was dismissed,
Yes.
restored in 2022 after 7 years.
Yes.
So you were removed in that interval.
My lord,
No, no,
his
after
order of
20
disengagement, that is on 8/6/23, your lordship.
23
2020.
after the writ application had been restored. 8/6 no, the second time.
2023. And they have referred, yes.
Sir, you have taken
Very
much
lucky.
advantage of.
No, it's not my.
Restored after 7 years. They still working. And again it was dismissed for want of instruction.
No, this Honorable Court, what is that? There is no Wakalatnama on my behalf in the writ petition.
No, we are not there.
Yes.
But fact remains that you have been removed.
Yes.
2023.
Yes. Referring to order of this Honorable Court, madam.
He can challenge order.
Okay.
He can challenge that order
He can,
twice.
he can.
I filed writ petition.
You have already filed.
Already
Yes.
filed.
Already filed and counter agent is also there.
So this has become.
Against the order,
Pursue
the
that.
order of
Yes.
this engagement
But so far my.
passed in 2023.
Well,
Yes.
that order.
Passed
That order.
Even that.
on 8/6/2023, he has filed another writ application before this court, which is pending, registered as WPC number
20244, 2023.
20244 of 2023. So, next. After having heard learned counsel appearing on behalf of the petition and AGA for the estate, and after having gone through the impugned order passed by this court, passed by the tribunal, we are of the view that the order of the tribunal suffers from no legal infirmity. So it is and counsel for the petitioner has further submitted that the order passed by the tribunal is erroneous also on the ground that the petitioner's relief has been rejected on the ground that his initial engagement was contrary to rules, whereas there were no rules framed for appointment against the post of field or post.
One
It
aspect.
is an admitted position that the petitioner continued on ad hoc basis under an interim order under interim orders passed by the tribunal as noted above. So the present writ application was filed in the year 2010, assailing the order of the tribunal, which was firstly dismissed in 2017 and subsequently restored in when?
No, first 2015, restored in
15.
Again, it has been dismissed on 10/4/2015.
It was restored on
May,
2020.
yes, may I submit my lords? What has happened, my lords, while restoring the writ petition, my lords, since I submitted on behalf of the petitioner that I am still continuing, so that is why this honorable court wanted the instruction from the state council that you submit on the next date whether the petition is continuing or
Now it is
that.
clear.
That instruction was supposed to be furnished by the state council. Your lordship, I will
That
see-
you have furnished.
No, that he was supposed to be furnished, but when the case was listed, my lords, the instruction which was supposed to be furnished by the London State Council, the honorable court was on the was with the impression that I am to suppose that instruction. That is why, since I was absent because my wakalat number was not there.
All that is material.
So, one thing, your lordship, I will take your lordship's permission. So that was not on my fault, my lordship.
It was 2022. So the writ petition was again discussed for default in 2023.
Yes.
2010
10/4/2020.
for 2023. And restored by an order dated
12/7.
12/7/2023.
12/7. May I pray?
When was he disengaged?
Disengaged, my lords, 8/6.
Disengaged on 8/6/2023.
8/6.
Before the restoration of, in the meanwhile, the petitioner was disengaged from service by an order dated 8/6/2023, which is pending. Against which the petitioner filed the petition, filed a writ petition, which is pending, as has been noted upon. So, next. We do not find any legal infirmity in the order passed by the tribunal in view of the admitted facts that the petitioner had approached the tribunal in the year 1994, less than 2 years of his engagement on ad hoc basis in 1992, whereafter he continued to work under interim order passed by the tribunal. So, the tribunal, in the said background, rightly relying on the Supreme Court's decision in case of Uma Devi, dismissed his case for regularization. So, this, accordingly, we do not find any merit in this application, which is dismissed. Yes.
Your lordship's permission to, I have filed one additional affidavit here in this case, my lord, bringing it to your lordship's notice that even persons who are continuing on the strength
Not
of,
here, not here. We are testing the correctness of that order, that's all.
I am just bringing to your lordship that I have,
If the other writ petition is pending, you pursue that.
that I will pursue, my lord. So far the regulation party is concerned, my lord, the persons who are continuing, even appointed much after my appointment and continuing on the strength of the order of the learned tribunal, my
Don't
lord.
compel us to make.
Yes, I am not completely relying
Observations.
upon the same judgment of Uma Devi. The honorable tribunal, the learned tribunal passed the order that was confirmed by this honorable court
All right.
and also confirmed by the
All
honorable
the
appellate
next
court.
is- all the-
Item 13.
Right.
My lord, file has been transferred. The name of our office in the name of Senior Advocate Mr. Jagannath Patnaik may be deleted. My lord.
Yes. Made please, Lords. Yes. This is a matter where the lease granted in favor of the petitioner's father.
Which item?
Item 13, my lord. The OGLS matter.
Yes, just a minute.
Data का picture में. Data का picture.
Yes. 13. Item 13, yes.
I'll take your lordship to the date chart first, then I'll take your lordship to the impugned order, my lord. Girija Hussain Patnaik applied for a lease of piece of land near Bhubaneswar for plantation of herbal medicine plant that comes under the agriculture and horticulture, my lord. On 29/5/74, Tahsildar Bhubaneswar initiated lease case WL number 590 of 74, and after due inquiry, on being satisfied on the eligibility of Girija Hussain Patnaik, granted lease of 2 acres in respect of plot number 2107 under Khata number so-and-so for agricultural purpose, holding Girija Hussain as a landless agricultural laborer, in pursuant to which Jamabandi register was prepared. There is Annexure 2. The additional district magistrate in 1986 initiated a so much revision on section 7A3 of the OGLS Act and cancelled the lease. But that was objected by GS Girija Hussain, and the additional district magistrate after cancellation cancelled on 29/9/1987. That was challenged before the Honorable High Court in OJC 2481 of 88. One of the ground of challenge that it was not maintainable as such. The Honorable High Court set aside the order and remanded back the matter, saying that all the objections taken should be taken into consideration, and then a final order has to be passed.
No, but whether the lease was perpetual.
Lease was perpetual, my lord.
Where is that?
The lease that was granted in WKLs, that is usually for 99 years.
Where is you? There is no question of usually. There must be mentioned in the agreement itself. Where is the agreement?
So lease on that Jamabandi is there, my lord. If your lordship looks at, I have filed it, my lord. The Jamabandi is Annexure 2, my lord. If your lordship kindly see. Page 20.
But Jamabandi is not lease. Where is the lease deed?
After the lease was granted, this pata has been granted. Entry has been made, where he becomes
Jamabandi.
The title holder as Sthitivan right holder. He becomes an occupancy.
What is the effect of Jamabandi?
Effect of Jamabandi is there that has been granted. The Sthitivan right has been created, and on the basis of that, a pata is granted. This Jamabandi. So my name has been recorded in the against the plot in Khata, saying that I have the title holder of the property.
No.
Earlier, Mr.
Jamabandi will not imply
the rent.
It doesn't create title, but it acknowledges title.
All right, let us see. Your case can be decided on the basis of lease deed only, nothing else. So there are two aspects, not only lease deed, whether the lease was granted properly, and in that background, whether the order passed by the revisional authority was correct or not is one. And two, even if the order of the collector of the additional collector was wrong, whether the cause of action survives after the death of the original lessee. These are two questions.
After the
Death of the original lessee. Lessee is not alive.
This is not alive.
So therefore, the agreement was for a particular purpose, the lease was granted to A.
Yes.
So whether you could step into the shoes after this.
So these,
therefore, lease agreement is very
for
important.
with due respect, my lord, these leases are hereditary.
How can we decipher?
With absence of the lease deed.
My lord,
Where is the lease deed?
so here actually no lease deed is executed in WL case. In Westland lease case,
okay,
what happens actually in Bhubaneswar at the earliest possible time, my lord, nobody was there in Bhubaneswar. In fact, initially the capital was set up. They wanted to lease in registering a WL case to different person who makes an application. That is how actually Bhubaneswar developed. In fact, it was all bushy and
So what is WL?
Westland lease case.
All right. So there must be some case, there must be some order.
Yes, order has been passed.
Where is that? With the revision order is here.
WL case order lease has been passed. The order has been passed. On that basis, actually.
But it is very difficult to accept that without any lease deed.
They don't execute any lease deed, my lord. Up to number of cases, ask the government also if they can produce any lease in respect of any lease. All the persons are in possession of the land and they are continuing since the last maybe 30 years, 40 years,
No, sold,
50 years.
sold, resold, replotted.
Yes, you're correct.
Where is that order? That 74 order, where is it? 99.5, 1974.
Yes. 31, that improved notice is 31. If your lordship turns to
Filing.
filing, initial order.
That order is not there, Lord.
That order is not there.
Because in the absence of the lease deed, that order is important.
Order was there. There is no dispute because they themselves opened the case, initiated the suo motu case by challenging that order.
Because saying that proper inquiry has not
Yes,
been
yes.
conducted. So that order is important.
That order is there in the impugned order they have referred to. My response to submission will be, well, that act is not applicable. It was granted on the lease principle.
What is the lease
62
principle?
Act.
What is the lease principle?
Approved lease principle is a set of executive instructions which was given the authority of law in the absence of any statute. So on the basis of this lease principle, approved lease principle, all leases have been granted till the rule came into force. The act came in 1962. There was no rule as such grant. So in the absence of the rule, this approved lease principle was adopted and they have granted lease. It has a different procedure altogether. In different decisions, it has been held that once you have granted the approved lease principle, you cannot make applicable to OGLS Act. And you cannot cancel a lease on the basis of applicable OGSL Act. Because if your lordship looks at section 7A3, it says any order passed.
OGLS rules were
Date.
The rule came in 1974. I've got a copy of it, Maran.
And it
74
was granted in your favor when?
I've got copies, Maran. It may not be there in the book.
Rules are not clear.
It
So
came out
according to
codified
you,
in
this will
11th
not
December
apply in your
1970.
case.
Sir?
These rules will not apply in your case.
No. Prior to that, it has been granted. And 86, they made a consolidated at length full detailed rule again, superseding this one. And if you also looks at the language in orders section 7A3, so kindly have a look at section 7A3, the language. This has also been amended from time to time. subsection 3 of section 7A, capital A. It says, notwithstanding anything contained.
Yes.
Notwithstanding anything contained in this act or any other law, the collector may, on his own motion or otherwise, call for and examine the records of any proceeding in which the authority subordinate to him has passed an order under this act. This word is also taken note of in different decisions. So any decision taken or lease granted under this act will only be reopened under section 7A3. Can't be otherwise. Even number of cases where actually these Jawan leases were granted under the lease principle, under the same approved lease principle.
No, where are those lease principles?
Beg your pardon, my lord?
Where are those lease principles?
It is then there is a compilation of the, I think, there. Approved lease principle. Okay. Page 413.
This was taken for agricultural purpose.
Right. Agriculture, horticulture. He's doing that also. The report also there, 2008 report is there. One of the interesting feature is, if Lordship looks at, High Court passed an order in 1986. But the order has been passed in 2010.
But does this apply for agricultural purpose?
Yes,
Where?
agriculture and horticulture, that's right.
Where?
Herbal.
No, this lease principles. Everywhere I find homestead and
Approved lease principle. is applicable to agriculture. Settlement of land for agricultural purpose.
Where, which heading?
So 413 page.
13, first.
Said
Yes, yes.
it was prior to the Act came into force, 1961 government order.
Yes, let us see the press which you are referring to. Yes. Lease
413 minutes.
Yes.
So that is this notification was, this government order was followed while granting the lease merit. So there is a provision for appeal also there. If somebody is aggrieved.
No, what is the principle?
Principle is that if somebody wants to have land for agriculture land, he can apply.
So
And
anyone, like someone from Bihar could apply. Bhubaneswar.
So that maybe possibly he has inhabited, he has settled here.
Let us see, therefore when we are examining,
Yes, Bharat. But if somebody has come and settled here, he is definitely.
No question of having settled. If he lives there and if he finds that there is
So it doesn't restrict anything, in fact. If Lordship looks at it, doesn't restrict. I think a person can come and apply and can get it.
Provided that person doesn't have land more than 5 acres. So that
So
is
that came, the rule came much after. Well, that 5 acres.
No, it is there in this
No.
principle.
If your Lordship looks at.
Applicants who have no land or less than 5 acres in the family can be settled with land of
this person is not, is a landless person.
That's why I'm saying that this is the. It can't be landless.
So which part of this lease principle you are relying on? So how did you apply? Where did you apply? Why did you apply?
Even clause 12 at page 419 says, appeal lies to the sub-regional officer or the pass-based tahsildar on additional.
There is no question of appeal. That power is there, that reasonable power is there. That you are not disputing.
If any time within so and so, there has been
3 years from the appellate decision of the collector, deputy collectors, the time is already over. It's 74. The question is applicability of OGLS Act 7A3. 7A3 doesn't have any application. They have done it on the 7A3 and the impugned order after 18 years from your Lordship's order deals with it, refers that no recordable. LCR is not available. The inquiry report is in favor of the petitioner. And interestingly, it has been specifically mentioned there that the agriculture operation is going on, horticulture operation is going on. He is in possession and is.
That is not the question. Question is whether the lease was validly granted in your favor or not. That is the main question.
Right.
So what was the basis?
So basis is this: when he made an application, it was considered, and an inquiry.
Application under which provision?
On the lease principle, approved lease.
Where is that?
Or that they can produce the record.
No. Where is that under the lease principles? We want to understand. We don't.
Right.
At least speaking for myself, I don't know
No, I understand.
the scheme here.
But if your lordship look, the opening word is settlement shall be made village body, all applicants pending in the village on 1st June 1961, all enforcement up to the date which was not so and so. And in future, every year applications received from 1st June of the previous year, 31st May, shall be considered in batch and disposed of.
By whom?
By the,
Where is that?
if your lordship looks at, the Tahsildar has got the power to do that. Authority for grant of lease, clause 12. The Tahsildar of the area, or where there is no Tahsildar, the subdivisional officer shall be the authority competent to decide on settlement of land according to the above principle annually.
Court has held that petitioner is not a landless person, which will be a vital consideration for the authority. But since the order is
Nothing was there, my lord. On what basis, my lord, such a finding is arrived at?
no, but this High Court has held that.
Yeah. No,
High Court has
no,
observed that.
High Court has not said this is a
There is
contended.
undoubtedly much force in the contention of the learned
Contention.
government advocate. Yes, there is
Only
much
contention
force
has been recorded.
that there is much force.
Yes.
So what? That is not the contention. That is the observation of the court.
Right.
Yes, that the petitioner
That
is
has
not
been
a
decided.
landless person, and that would be a vital consideration for the authority.
Exactly.
Yes.
Yes, if your lordship looking at, may I pray lordship may come to page 24, Milors. Page 24, his objection. Milors, seventh line, that a lease was granted under the provisions of the Orissa Government Land Settlement Act, but subsequently the record of right has been created under the provisions of survey settlements. So now how can you say that it has been settled under the lease principles?
Sir, actually it was not done, with due respect, my lord.
Act was not enforced.
No, Act came in 62, Milors. Act came in 62.
But he has got it for that.
So
No, 74.
No.
Oh, acha. Rules had not come.
Yes.
Not come into force. They cannot be under that.
And the observation of this honorable court is that his objection will be confined to this objection only, not beyond that.
But that's a law. There's a question of laws. Rule was not there.
Rule is for the procedure.
The rule was not there. Without procedure, they cannot be implemented.
And by the time he made an application, lease principle 61 has gone and specific act had come into force in 62. And
No,
all
sir.
applications under the OGLS were there for settlement of land.
No, that's not correct. With due respect, sir, both continued, my lord. The lease principle still continued. It continued till 1987. The government record will show. No, with due respect.
Yeah.
After 86, it ceased because 86 they consolidated to force.
Oh, is this your submission?
Sir, ma'am.
That because the rules were not framed
Yes, my lord.
under the Act,
Yes.
therefore the provisions of the Act could be violated?
No, the provisions of the act under which no lease was granted.
No. See, Odisha Government Land Settlement Act 1962 is there.
62.
According to the Act required framing of rules.
Right.
Before that, according to you, there were lease principles.
Right.
All right. So, despite 1962 Act, the following those rules, the lease could be granted even if they were in violation of the provisions of the Act, because there were no rules.
No rule. But not violation, with due respect.
Right.
It
Therefore,
proceeded as per the provision contained.
Very good. So therefore, you say that if any land was to be settled,
right,
that was to be settled without breaching provisions of 1962 Act.
Yes, ma'am.
All right.
Yes.
So you cannot say that 1962 Act is not applicable.
Sir, with due respect, my lord, 62 Act applicable to the limited extent, right?
So whatever extent.
Right. Then no procedure was there to be followed. Therefore, they followed the lease principle.
They might have followed the lease principles,
Right.
but they could not violate the provisions of the Act. So therefore, when you say that OGLS Act shall have no application at all, or the consideration of your case cannot be accepted. That you are saying that yes, they could have done it, but without violating the provisions of the Act.
Sir, your lordship is rightly putting the question to me, lord. Sir, OGLS Act was in existence. When the lease was to be granted, they have to proceed with a particular rule. Rule was not there for grant of the lease.
Yes, so your question is that rules which came into force later, that will
Right.
not apply, the lease principles will
So
apply.
make
This
application.
is our question.
Vis-a-vis the rules.
This is our question.
Right.
Is this your submission? That because rules were not framed,
Therefore, Act was not implemented.
therefore the Act could not be implemented.
No, that is his
Therefore,
submission.
therefore, they were at liberty to breach the provisions of
So
the
the
Act.
breach, sir, the word breach is not there.
Yes.
With
the
due
moment,
respect,
the
Lord.
moment you say that this Act has no applicability, then this is your submission that irrespective of the Act, the Tahsildar was independent to take any decision because it was not workable in the absence of rules.
So I'll just put one mode of argument for your lordship's appreciation, my lord. But assuming for the sake of argument, the Act was applicable. The ADM actually found fault referring to all the rules which came much after.
That is why it was remanded for fresh decision.
Yes.
Yes, thereafter.
No. The rules which came subsequently after the lease was granted, the ADM follows those rules to say that there is a fault. Those rules are not applicable.
There you may be right.
Those rules are prospective. Those rules cannot be made retrospective because at the relevant time, the provisions contained in the rules were not supposed to be followed. Therefore, the ADM, while exercising power, is now referring to those rules which came in 1986.
Yes.
But may I just read the impugned order, if your lordship will appreciate. The impugned order itself is absolutely unjustified.
Yes.
You have the records of no, because here it is sent that it has been sent. You have the original
Records
records.
of the revisional code, no? I've got the original records.
The revisional code, okay.
Revisional code.
Right.
Not the trial.
No, code had asked her to get it
Oh,
from the revisional code, so.
Sir, if your lordship looks at page 32 first, my lord.
Paper. Acha.
So where is the provision under the lease principles?
My lord.
Or what is the qualification for a person to be considered?
If your lordship looks at clause 2, priority of settlement, my lord. At page 415, as regards the settlement of lands other than the encroached lands leased out. My lord, got that 415 top, my lord.
Yeah.
As regards the settlement of land other than the encroached land to be leased out, there is however hardly any need for making any provision for settling such land with persons having lands exceeding 5 acres. Such lands may be settled with only persons having lands less than 5 acres to the extent of 5 acres only, inclusive of his own land, on payment of premium of salami at a flat rate. The final disposal, officer authorized settlement shall consult the concerned Gram Panchayat or local body and then finalize the list of allottees. The local bodies shall furnish their recommendations to the officer within a month after receipt of the requisition of the same. Government will have the right to reduce or give up salami for settlement of land with 4 members of the primitive tribe or had cases due to poverty of recommendation of the collector. Subject to overall, in areas where the scheduled tribe predominance, especially in settled area and in each class of list of priority, scheduled tribes will get preference over the others. Subject to overall preference of scheduled tribe mentioned in clause A above, scheduled caste applicants shall preference in each class. The landless belonging to the backward classes and other landless people will get preference. Next to the landless scheduled tribe and scheduled caste, person shall be deemed to be landless if he has either no land or land below half an acre per member of the family living in maize. Each class of applicants shall be considered together and disposed of before going to the next class of these priorities. And applicants who have no land or less
So
than
is there any criteria that he must not have any profitable livelihood? Where is that? Because the ADM has relied on a decision of the High Court in Bhawari Lal Agrawal versus Tahsildar in page 17 of your writ petition.
No, just page 17.
Page 17. And the observation of the court is at page 18.
I'm just. That was given for excavation of a tank.
Yes, but it says
excavation of a tank and construction of house.
oh,
That Banwari Lal Agrawal versus Tahsildar at Malik.
It's probably described in the act as person. Person is described in the act.
Tank.
There it is stated about the income.
Income. But he had no income in fact. At the
He had
relevant
no
time.
income. The
Old 1962 Act.
The lease principle, there is provision for what is the income was not there, and he was actually had no income as such.
No, he records in the order. In the order.
Puruna local act.
Revisional court orders are without any record, with due respect, my lord. Nothing was available. How can they arrive at such a conclusion?
If nothing was recorded, then nothing will be your favor also.
No, nothing in the sense the income, my wife's salary. How could it? Nothing has been produced before him. Nobody was examined. Nothing was placed before the
So
ADM.
we are exercising great jurisdiction. File an affidavit that these findings are incorrect. Have you said?
But I have taken ground, but this is all error.
You will say that.
Yes, yes.
You examine that affidavit. If you have stated in your
No, in the writ, I have said that he has taken extraneous matters.
Maybe we are in great jurisdiction.
But I want that he also to examine it. I just want that. That is exactly I want.
No, you say we can examine only if you say. We can examine. See, the main allegation against you was that you obtained the settlement fraudulently.
Sir, there is no finding of
eligible. According to you, there is no fraud because there is no document available.
The document in the sense the LCR was not available before the ADM at the time of adjudication of the matter.
All right. So
LCR contains everything.
The finding may be incorrect. That your wife was a professor, this finding is incorrect. Your income was so much, that finding may be incorrect. You say that. On affidavit, we will accept. You say that the finding is incorrect. So you are entitled, you are eligible. At least this much you will have to state.
So that is one part of it, with due respect, my lord. The principle on the basis of which it has been given at the relevant time, income was not a criteria. Its criteria was landless. Income was not a criteria. Income came in the rules.
Act is 62, but with amendments it is there.
Series of I have got all the amendment copies. I can give a compilation to your lordship, my lord. From the beginning itself, the 62 Act came into force in 1965, in fact. 62 Act came into force in 1965. And the
You have the original act.
all the provisions I can give a compilation. It is better if your lordship wants to see all those things, but I'm ready to show your lordship and apprise your lordship about the position of law. That new compilation is not there, my lord. New Act doesn't provide anything. The old things have not been incorporated. They should have given those amended provisions also.
This has the amended provisions.
Then
This has the amended provisions.
no, they have not given the subsequent developments of the Act from the time with which it was enacted.
That they have not given. They have given whatever they found. They have given 1990 amendment. They have given.
Right.
So that is why I was asking whether you have the original act. In your office.
And there.
No, like this subsection 3 of section 3.
Yes, my lord. Section 3 of subsection 3.
Definition of person.
Section 3 is actor action. OGS Act. No, I don't say that.
Mr. Samantray,
No.
old act also may be there in your office also, AG office, old act.
Yes, I can get it.
The library.
Library also must be there.
Could you see that?
Yes, my lord.
Could you see subsection 3?
Subsection 3, my lord. The settlement of land. So that has been amended in 1974.
That was granted in 1974.
No, it is after the lease was granted.
All right. So what is the, therefore you want to know the date. Date
Right.
is not mentioned.
Right. No, I'll give you, let's say, a
It is not
compilation.
mentioned. It says any landless agricultural laborers of
Yes.
the village in which the land is situated.
Right.
Or any neighboring village.
Date of
Neighboring
amendment.
Because 1974 is
It was
stated
came in
without,
1974.
without saying the
After the
date.
lease was granted.
Therefore, we wanted to know whether someone from Bihar applied.
It came in December 74.
We will take up on 22nd.
Yes, ma'am.
Please, in the meanwhile, just go through the act right from the beginning. What was the crucial date is the date of settlement in his favor.
Right.
All right. So under the act, as existing on that day, whether he was eligible or not.
Right.
All right. If he was not eligible, we are not disputing the findings recorded by the revisional authority, but at the same time, we are not accept for the present because he says that these are extraneous. These matters were not before him. Maybe.
Right.
But while exercising this jurisdiction, when certain facts have emerged, they have a duty to say.
Right.
So they will be disclosing that.
Right. But I accept that.
As jointly requested on behalf of the party, this matter on 22nd.
So the revision case, does it have the original inquiry report?
Yes, ma'am.
Yes.
Inquiry report I have filed, madam.
Subsequent inquiry problem.
Subsequent 2008. They themselves inquired.
No, 2008 you are saying there is a growth there.
Yes.
This is 2008. When was
But
that?
it continues from that time itself. Well, can it be 29th, my lord? Since Thursday you are also taking 22nd, I think.
29th.
Great. That interim order is there, madam.
Interim orders have continued. You are enjoying interim orders since 2000 when?
No, in between also this had been dismissed, again restored.
Restored.
Dismissed in 2020, restored. Interim order was restored.
Ah, it has been recorded and.
Restored with interim order.
Item number 14.
I'll give a compilation of those acts and rules for your lordship appreciation.
Please examine, Mr. Sam.
Yes, sir, we will examine. It's in item number 14. Last occasion, my friend who has directly solved a copy of it. He has given it, but he has given it a bit late, so I could not get the instruction. We are also directing after specific instruction. So
What is this matter about?
It will challenge the order of the member board of revenue. The illegality of the illegality and impropriety of the order under Annexion 9.
What is the illegality?
The illegality was the OEARC. The case was initiated under the OEA Act and it was disposed of under the OSS Act, Odisha Survey and Settlement Act. Then the limitation period has to be taken into consideration by the member board of revenue where it has been not been taken into consideration, and after a lapse of 24 years, the present case was instituted.
So what is wrong? What is the legality?
My lord, the illegality is that the very initiation of the present proceeding by the collector, my lord. My lord, the petition filed by the collector may kindly be seen at Annexure 6, my lord.
The application.
Yesterday, my lord.
only.
So then you're saved from paying cost.
No, in fact,
There was an order, if you don't file counter, you'll.
yes, no.
Say something.
Yesterday only the copy was given, even not without, because it's a accessory matter, without counter, I cannot, so, because, no, I will not insist on counter, I can assist your lordships for disposal on the basis of records,
So
lordship.
you're ready?
Ready means not, it's a accessory proceeding, lordship. I can go through records and dispose.
Some particular.
So someone fell and AG has informed the court that affidavit could not be filed despite this court's order dated 1/8/2024 because copy of the writ application came to be served upon him yesterday only by learned counsel for the petitioner. So place this matter on 22/8/2024 by which state a counter affidavit must be filed.
Item 15.
My lord, interim order to be continued, my lord. Oh, bless.
Yes.
Item 15 matters. It's a matter matters PIL, a private pond, admitted matters, it is a private pond. A big size pond, private pond at Barampur. Then matters there was water crunch and lot of private people matters they have constructed ponds. One of the pond they wanted to convert it to matters and to sell it to some other person, converting it to matters.
Which item? 15.
At 15 matters.
Yeah.
To convert it to matters homestead and municipality matters wanted it in garbage, and then thereafter matters to carve it and to construct it matters to carve out the plots and then to sell it. I have come before the Honorable Court referring to a decision of our Honorable High Court, which has taken note of all decision of Honorable Supreme Court, so far as the
It is a PIL.
is in form of a PIL to protect that pond. That is the whole contention is to protect that pond in the greater interest of the public, and that is the case matters. There is a decision of our Honorable High Court dealing with all these details matters. I've got that copy of the judgment.
At Jala.
That incidentally, I was also party to that case.
So that is why I was surprised that you are here for the petitioner instead.
No, here in this case, I wanted. There I supported.
No, here you are Barampur, so you can be for the
not
petitioner.
Barampur.
This one?
That case, in that.
No, this is not Barampur. This is Barampur.
This is Barampur. Yes. In that case, that is Cuttack. In Cuttack case, I was for the Cuttack Development Authority and I was supporting the cause.
Exactly.
I was supporting the cause.
So here also same cause you are supporting.
Same cause, my lords. I want that the sales procedure to be adopted. Here in this case, my lords, in Cuttack. Sir, what is the copy of the judgment? Who copy of the judgment?
Ashirvad Patnaik.
Minutes?
In case of Ashirvad Patnaik.
No, minutes. It is Tapan Kumar Das.
Because one judgment is here.
That the Honorable High Court Division Bench dealt with all the decisions of the Honorable Supreme Court and have come to conclusion concerning Cuttack. And there, my Honorable Court has said, suppose from tank which has lost its character, then Tahsildar is to move it to the collector, then collector to RDC. RDC will constitute a bigger size of committee comprising of members. Then if they will permit, then only. Here in this case, the private tanks also, so far as private tanks. In the process, my lords, the character of the tank cannot be allowed to be changed. The tank should remain as it is. That is what is the decision of the Honorable High Court, my lords. That is I referred to, and in this case, my simple prayer, the municipal corporation should come up. That is what my lords have directed here. Last occasion directed the municipal corporation to file an affidavit. The municipal corporation has come up and filed an affidavit. To that, I have also filed a rejoinder that they say that this is a tank, but tank is not being well maintained. And if it is not being well maintained by the private party, the municipality melts under the Municipal Corporation Act enjoys power to give them direction to do it, to make it habitable.
This tank belongs to a private party.
Yes, that is admitted fact.
Who is the private party?
Private party.
I'm appearing for him, Your Lordship. I'm appearing for the private party.
Come this.
It's only for Cuttack or other places that the municipalities also
municipality.
it has a duty to maintain the tank also, even private parties.
That so far as the government tanks, so far the private. I've given that judgment, my lords. There also there is an observation in corruption that the state government can adopt it in respect of other cities also. There on the court laid down the procedure.
So where is the direction that even the private parties are required to maintain the tank?
Well, there.
The direction refers to the affidavit without giving the details.
Giving the details.
And act upon the report dated so and so.
Where is that observation?
That observation, my lords, required that observation that the private tanks.
Where?
The private tanks to be maintained.
Where is that?
I'm coming.
Maintaining the private tank and filling the private tank. These are
Two different things. Two different things. Right, my lords. Here in this case, they are trying to fill it up, not maintaining. So trying to fill it to convert, to change the land use from tank to homestead. That is what I have come.
So where is the direction?
So see, this direction is to maintain the tank.
Where is that?
I'm coming.
Yes, page 951.
956 minutes. Clause 4. Clause 1 to 4 minutes, that is the guideline.
Just a minute.
Paragraph 9.
Paragraph 9 minutes.
The committee
Recommended. Paragraph 9. Committee headed by RDC.
31A.
Yes.
That all tanks, water bodies available physically in Cuttack city should be preserved for future use, irrespective of the classification.
Yes, madam.
9.
Confusion leads to reports and representations. The government can act upon the report, the other one which is specified.
The 2 minutes.
All water. Perspective of the country, everything produces.
grievance in this application?
My grievance is twofold. This should be maintained as it is, and
So
it should
you
not
have
be.
grievance against only his pond tank or everyone?
Every pond, my lords. Here in this case, I targeted one tank for the reason that it was going to be filled up by the municipality throwing the garbages.
Oh.
Throwing the garbages. So in the process, what is happening now is healing of the pond, part of the pond. So my humble contention.
So the private land municipality was going to.
Municipal throwing garbages, my lords.
No, your lordship.
This is another way of also converting the.
I am
Already you take up.
my lord, your
May I
lordship,
pray, my lords? May I pray, my lords? May I pray, my lords? I have a small prayer, my lords. My lords was pleased to fix the PIL bench, my lords, today, my lords, at 2 p.m.
Okay.
That there, my lords, personal appearance of the secretary to assist the honorable court in that PIL bench. May I pray, my lord, taken up on Monday?
Monday we
Next
cannot.
Thursday.
Cannot take. We'll take up better on 22nd.
22nd.
Government.
Okay, ma'am.
22nd.
Item number 42.
May it please, ma'am. Petitioners before your lordship, my lords, are 154 in number. Who are, my lords, photographers in the before this at Konarak, and they have been eking out a living from my lord, from doing the performing for photography, my lords, for more than 20 years. Now, my lords, in 2007, suddenly the petitioners, my lords, they came up with a my lords, a order, memorandum, administrative order was issued that you have to take license. Only then you will be permitted inside the temple. So all these petitioners, my lords, they applied for the license. At the time of my lords, initial pursuant to the my lords, the advertisement under Annexure 1. So this license condition, my lords, initially at page 27 of my writ appeal, your lordship will find. This was the condition of the initial 2007 license, my lords. 1. Any photographer who is a citizen of India and not below.
You are at page?
My lords.
You are at page?
At 27.
27 of?
The writ appeal. Appeal number 81.
So writ appeal is from 1 to 39. And annexure 1 is at page 40.
My lords, I have quoted annexure at 40, but I have extracted that those.
Okay.
Qualification requirements in the advertisement I have quoted, extracted in my application. Any photographer who's a citizen of and not below 18 years of age and possesses the requisite skill and expertise to operate a still camera shall be eligible to apply for a license for photography. The applicant for license need not necessarily own a studio. The applicant shall be required to submit along with his application proof of his age. No applicant shall be eligible to submit more than one application. 4. The applicant's application received for licenses shall be scrutinized and recommended by a committee constituted by the Director of Archaeological Survey of India for issuance of license. The decision of the Director General Archaeological Survey of India in this regard shall be final. The 5. The application shall be addressed in favor of the superintendent engineer. The application should reach within 15 days. Person selected.
Sorry for interrupting. You are agreed by which?
We are agreed by the second advertisement, the second eligibility condition issued in 2017 by virtue which was introduced into the rule, virtue of an amendment which comes in as late as 2016. So after the amendment, because we submitted applications in 2007, they were kept pending for 10 years. They did not do anything on the license, for grant of license. And then, 2017, the rules come in and the regulations under the rules they come in. There, they introduce a new set of eligibility criteria. I am aggrieved by the one, eligibility condition 1, that your lordship finds at page 29. Eligibility condition, that is educational qualifications, matriculation, 10th pass, and 1 year diploma in photography, or 5 years experience in photography at tourist places. This is what I'm with. Now, after 20 years, or some more than 30 years, we have been eking out a living by doing the photography in tourist places, whatever meager earnings that we have, and we are running our families. And after 30 years and more than 2-3 decades, they now ask us to get a matriculation certificate, thereby putting it beyond us.
That is a rule or a guideline?
It's a guideline.
Where is it?
Guideline is at page
43.
Annexure 2. Annexure 2, that's at 41, starts at page 41. So 43 is the eligibility requirement.
43.
So I am basically hit by that. Otherwise, my lord, your lordship had taken a sympathetic view, taking into consideration all that, my lords, by your lordship's order, dated, my lords, 28/9/2022. Lordships had passed an order, division bench. If your lordship permits, my lord, I'll place that order.
Which order?
Order dated 28/9/2022, passed by your lordships, my lords. A interim direction was also issued for them to formulate a policy, modify the policy a little bit so that we can all be adjusted and accommodated, since it's a question of our livelihood. Order number 12 of your lordship, my lords. If your lordship permits that order, the appeal raises the issue concerning photographers at the Konark Monument. Some of them have been photographers for over 3 decades, but do not have minimum qualification or matriculation required under the policy framed in 2017
Did they
by
take any decision?
my lords.
Did they take any decision after this order?
My lords, they said that we are not in a position to tweak our policy. We will not. We are not in. They filed an affidavit. One, then, my lord, it had come before this successive Chief Justice. The Honorable successive Honorable Chief Justice also said that why don't you do something about it? It's a question of their livelihood. They said, no, we are limiting it to 78. We'll limit it to only 78. They said, then you come back with us and file an affidavit under which rule you are giving the what is the provision of law which authorizes you to limit it to 78. And then, my lords, they are yet they could not come up with anything. And thereafter it was before your lordship, my lords. Then, my lords, your lordship posed me a query as how, even if the court wants to the qualification regarding the embargo regarding the matriculation certificate, if that is creating an embargo, how that can be lifted was the issue, my lords. I have done a little bit of looking up on that, my lord. And there's also, my lords, another judgment of Delhi High Court, my lords, reported in 2018, Mata Prasad and others versus Union of India, where, my lords, the issue was there were 2 sets of photographers that have. Can your lordship permit me to pass on a copy of the judgments?
That is there at flag 2.
Yeah, flag 2. In this, my lords, the same policy was under, my lords, where the issue was, my lords, 2 sets of photographers. The 17 rule was also called into question, but then 2012 there were some licensed photographers, and 2017 some photographers had come before the Delhi High Court saying that, questioning that we can't, my lords, we can't be asked to take fresh licenses now under the new policy. So therefore, the Honorable Court segregated it into two sets. This is in in terms in that your lordship finds at paragraph 5.4. The ASI policy, ASI photographers policy notified and amended by the ASI acknowledges all old photographers having license granted by ASI prior to 2017. Clause 7.6 of the policy specifies that the licenses granted license granted prior to by ASI prior to 2012 shall be required to be revalidated subject to the condition subject to the condition that they will undergo a refresher course and test with tests conducted by the ASI. Now, our case is, we are not licensing. Our application for license was pending from 2007 and kept pending, as has been admitted, my lords, by the Council for the Central Government, my lords, for 10 years till the advent of the 2017 rules. And then they say you are disqualified because you don't have a matriculation. That is the typical situation in which, my lords, we are caught.
Matriculation or age also?
No, age and all that,
That's fine.
Age, whoever, that will not. But only matriculation is what is standing in our way. So my submission, my lords, I have to assist your lords, my lords, I can, I have only, my lords, one judgment of the Honorable Supreme Court, my lord. There are several judgments in this light. So, my lords, my submission before your lordship would be this: that if your lordship could read down this provision only and, my lords, delete severe the requirement of matriculation.
That will not amount to read down it. That will amount to unreading.
Well, that if your lordship could see, otherwise it's a question of livelihood, my lords. 154 families, they have nowhere to go.
Reading down.
But that you are working there, what is, you have some identity card or something?
Yes, we have identity card.
Issued by whom?
By the tourist officer. They subsequently say.
No, that's all right. They subsequently say we have not issued.
No, tourist officer was not authorized to it. Yes. But that was the identification. The collector had sat in a meeting and it was a big issue. So, and your lordships have protected us all along. Right from 2000, whenever we have been in court. Right from the inception, we have been.
These things are required to be regulated.
The regulations, we are absolutely on the same manners. One with your lordship, no question of we will every other condition we will satisfy, but matriculation.
Fulfill the age condition.
Fulfill the age condition. Minimum 18 years.
No, we are speaking of maximum.
Maximum 60.
So
maximum
fulfill.
60. Maximum 60, and the rules provide.
Just a minute, you fulfill.
Most of us are there.
Most of us.
Most of us.
All right.
Whoever is there, and
two of you fulfill. So how do they establish?
My lords.
How do they establish? Unless they have the matriculation certificate.
Now, my lords. My lord, Delhi High Court judgment. Flag 2. Delhi High Court judgment is flag 2.
Flag 2, para 21 alerts.
I have copy.
But that is there on record.
Is there on record?
Yes, yes. Page 561. The judgment flag 2.
Like 51 days. Yes, what is the opinion of the Delhi High Court?
The High Court says. Delhi High Court says.
Para 21.
Please allow him to argue.
Paragraph 21. They have treated two classes. In the contention of the petitioner that ASI photographers policy is sought to be applied retrospectively by the respondents, and it shall not be applicable to the patients totally misplaced. The aforesaid policy being applied prospectively, and all the persons who seek to operate as photographers in ASI monuments are liable to obtain license from ASI after participating in the aforesaid selection process. Merely because I have operated without license in the past, owing to policy in vogue at the material time that that part is against me. That paragraph 14 is in my favor, Manas.
Paragraph 14.
Here the distinction is they already had a license.
That the
So the problem of identification was not there.
Was not there.
Here
Already,
that is the main problem.
That's the main. They already had license and they were treated as two separate categories.
Take a refresher course.
Man, so therefore, oblige me not.
No, they are saying they have paragraph. Subsequently, AIR in the year 2016 issued draft rules. Proposed renewal of license granted to photographers prior to 2012. That means something was there.
Otherwise, the regulation, my lord, the intention of regulation is, my lords, very fair. The intentions of regulating them is very fair. There we have no, my lords, we cannot have any complaint on that score. That regulations, your lordship, find that is in terms of the my lord, the rule, page 22 of the.
No, but how this paragraph 14 supports it?
No, 14. I was only indicating that they have treated in.
And this deals with the same policy.
Yes. Same policy.
Then why should we eat?
Because that 14, in that sense that even the policy recognizes that persons who are before 12, they have been treated as a separate class and the licenses have been revalidated. And
same policy,
months,
which is under challenge before us,
months,
was under challenge before the Delhi High Court.
months,
The Delhi High Court has taken a view,
months,
definite view,
months.
that policy is national policy.
Months.
Should we take a view then what has been taken by Delhi High Court?
Now, there are a lot of factors which are not facts.
This is for the reason.
Months.
This is for the reason
Months.
that see, of course, the doctrine of committee applies in respect of two courts of different countries, but still we have to respect when same policy has been upheld should we rather, should we take a different view?
Facts were
Actually, we need to respect the orders passed by.
in my most respectful and humble submission, my lords. This aspect was probably, as a reading of this judgment, there are two things which, my lords. One is that the policy itself, 17, has been amended in 2018, wherein they have recognized that those who were prior to 2017, my lords, having licenses from 2012 onward.
It will create complete chaos if Delhi High Court holds this, Orissa, this, Bombay, this, in respect of the same provision.
It's a question of
After having noticed.
Well,
If we follow it, Mr. Palit, you don't have a license. That is the problem.
if your lordship follow balance, we are out.
Exactly.
We are out and we go home. After 30 years, we go home and starve. That is the human issue which your lordships took note of. The earlier bench manner they took, your lordships have always been very consistent in that view. That part your lordships have been, that was what the human consideration. That is what prompted your lordship. And this aspect was never discussed in the Delhi High Court. This vital aspect of livelihood, this was never brought under consideration.
That has been dealt with.
That hasn't been.
That has been dealt with.
My lords.
That has been dealt with, and that has been dealt with reference to the Supreme Court's decisions.
My lords. This is directly for, it's a question of livelihood under 21. What Delhi High Court decides is 19(1)(g).
Yes.
19(1)(g), right to do business and that aspect, and 14, class legislation. So therefore, Delhi High Court says that there are two classes. One class is those who are having a license prior to 12, prior to 17, and the other class, who are required to come in because the policy has a prospective operation. But this judgment, with great respect to the Delhi High Court judgment, there is, I could not find any reference to Article 21, right to life and livelihood. Right. That is what your lordships earlier ordered, 28(9). That is the spirit of your lordship's order. It was in that light. Your lordship that order.
Paragraph 17, that was what Delhi High Court has held.
17.
Reasonable policy notified by the AIC. The photographers, your problem is there is no identification that you have, you were working there earlier.
No, we have the identity cards are issued by the tourist officer, but that was an identity. That was an our identity was not in doubt. Identification was never in doubt. What your lordships, after considering all these aspects, my lords, your lordships have referred here at page 3 of your lordship's order dated 28/9/2022. Your lordship, in paragraph 7, I'll just place those two paragraphs, my lords. This appears. Mr. So-and-so states that if, paragraph 6, that if there is just one change in the 2000 policy not insisting on a minimum qualification matriculation, before your lordship was in paragraph 7 of this order of your lordship's, my lords, earlier order dated 28.
I've seen that order, sir.
My lords. That was the thrust of the.
All right, let us try.
That was the entire thrust of the argument, my lords. And that, it was on that platform, from that footing, your lordships examined the issue. So therefore, Delhi High Court was examining 19(1)(g), the reasonable restriction, and reasonable nexus 14. This is 21, my lords. I would most humbly and respectfully submitted that it's
Please appreciate this situation.
my lords.
That there is a policy of the Archaeological Survey of India.
My lords.
That policy has been upheld by the Delhi High Court.
My lords.
Policy is not a policy only for Delhi. That policy is for the whole country.
My lords.
If you want us to take a different view,
My lords.
and the same policy, you want us to say that that is illegal. So if we hold that, then what will happen? Whether our judgment will prevail in Delhi or not?
My lord, on facts, I'll assist you. I can only try to assist.
It's a question of whether the guidelines are constitutionally valid or not.
My lord, I can only attempt to assist your lordship on facts, and a very vital fact your lordship will, my lords, may kindly appreciate, my lords. Our application, there's an admission, there's a direct admission by the my lords ASI in the counter affidavit. Your lordship may kindly turn to paragraph page 68. That is the order of the Honorable Single Judge, which I am assailing before your lordship, my lords. Page 68, paragraph 3. I'll read that paragraph, my lords. Mr. Pradhan Learned Advocate appears on behalf of the Archaeological Survey of India. He submits preliminary counter affidavit was filed to the miss case, which is to be treated as counter to the writ petition as well. Position of his clients. Position of his clients that the licenses to be issued are to be in terms of 2017 guidelines. Stop. On query from the court, he under the old guidelines, they do not deal with it. Admission by them, that your lordship finds place in the order itself, the order of the Honorable Single Judge itself. And my lords, had they processed those applications at that point of time, my lords, then today we would not be here before your lordships. We would be all licensees, and we would be taking advantage of the Delhi High Court, the amendment of the policy. So we would be well covered with the policy. That is the discerning factual aspect, my lord. I can only pray and beseech your lordship that this is a fact which, my lords, cannot be lost sight of. This is the vital fact, and it has been by them, the ASI, that this fact was not before the Delhi High Court. That was not there, my lord. They did not want to take a license. And there, my lords, the plea was that since we are operating for long, we had to operate without license, and we will not be covered by the 17 guidelines. Here, my lord, what we are saying is our applications were there. We were compliant. In a way, my lords, we were regulation compliant. Not that we were not compliant with the regulations. We complied with the regulations and submitted the applications. They did not process it. And they don't give any explanation why they could not process it. They keep it pending until the advent of the new guidelines. So we were hit, in a sense, by a unforeseen circumstance for which we had no fault of ours. And they have not answered it, one way or the other, why they did not dispose of our applications. Because had those applications been disposed of, this writ petition would not have been here before your lordship. We would have all been taken care of. All 104 had applied under the old guidelines, out of which 110 had already been given identity cards. And my submission is to read down Mallet's lordship to save the petitioners from Mallet's.
Yes.
In this case, may I permit your lordship kindly, because I am appearing one of the intervener Miller. My application is also there at flag 4 of your lordship Miller. I am representing from the side of the association, which is formed since 1984.
We will not hear you for the reason that intervention is filed for opposing a prayer. So if you are opposing the petitioner, then it's all right. If you are not, then you cannot be heard.
With some facts, Miller, only to.
Where is the question of fact? We will dismiss your application. Where is that?
There is some facts is there.
No question of fact. Intervention is for opposition, not for supporting. Where is your
Miller, my application is at flag 4 of your lordship brief, Miller. That is IN number 987 of 2024, Miller.
IN number
all
987 of 2024. So, the Guide and Photographers Association, Sun Temple Konark, has filed the present application for intervention under Order 1, Rule 10 CPC, read with Chapter 6, Rule 27, bracketed A of the Odisha High Court Rules 1948. So, it is an admitted case of the applicant that they are supporting the petitioners and not opposing the relief sought in the writ application. So, in the writ appeal. So strong. You are not party in the writ proceeding?
No, Miller. I was not.
The applicant was not a party in the writ proceeding. In such circumstance, this application seeking intervention to support the appellant by a person who was not a party in the writ proceeding is only misconceived and is accordingly dismissed.
And they
Yes.
are also not a panelist.
Yes.
My lord, pursuant to the orders of this honorable court, dated 9/2022, order 12, on submission of my lord seniors, that the 154 persons having the identity card issued by the state authority. Subsequently, then my lord such.
You are for whom?
My lord, yes, I am for yes, Appellate Sub. Subsequently, honorable court directed to consider the facts whether they can be adjusted or not. But after that, we have made a communication with the state administration. State has category stated that at page 18 of Fag X, page 18, in inviting a reference to the letter subject scenario, I am directed to say that no photographers have been granted identity cards by the tourist department for carrying photography business at this Sun Temple. So subsequently, no identity card, neither identity card nor license issued to these photographers. So for subsequently, orders dated
Had they applied in 2007 as per the earlier guidelines?
Whether they have applied, this is not, I have not.
There's an admission.
There was a 2007 advertisement and some of them applied, but this has not been dealt with.
Dealt with by who? The
That
single
is
judge.
department.
What was your reply to that? That they had applied in 2007. What was your counter? What did you say in your counter?
That is in 2012, the new guidelines came, and 2017 and 18 subsequent guidelines.
That is all right. My question is that the earlier guideline which they say that they had applied and you did not deal with their applications, what is answer in your counter affidavit?
That in the advertisement it was for 3 years only. That in the advertisement was for 3 years. That is at page 40.
What is your reply to the assertion that they had applied in 2007 and you have not dealt with their applications, either rejecting or allowing?
That specifically not I have replied in the counter affidavit, but so far as the advertisement was concerned, page.
That advertisement is Annexure 1.
Well, it's Annexure 1.
Plus,
No, Annexure 1 is something.
receipt of the prescribed fee, superintendent archaeological survey.
No, where is that advertisement of 2007?
Guidelines, I think, guidelines.
Guidelines.
40.
Page 40. That's the guidelines.
Guidelines.
That is where they ask for application for license.
Where is that?
This is page 40, Annexure 1.
Read appeal.
Writ appeal, Annexure 1, page 40. Running page 40.
Point number 8, man. On receipt of the prescribed license fee, the superintendent archaeological survey of India circle shall issue the requisites shall be valid for a period of 3 years to the concerned applicant along with the photograph identity and card within an appropriate order. Subsequently, due to 3 years, they have not been approached for this code in 2015.
No, we know that they have not approached, we know. What do you say to that?
Approached, and meantime they, and also
Did not approach because you allowed them to work.
we have not in view of the interim order scope.
Interim order in 2007?
No, 2015. In 2000, no regulation, no specific regulation or guideline was framed. Subsequently, in 2012 it came, and 2017.
You mean to say this Annexure 1 has not been issued by you?
Annexure 1 issued by you.
Then?
Annexure 1 issued by you.
Yes.
So throughout country.
Yes, throughout country you have issued this.
No. In specifically.
This was only for Odisha.
Odisha.
How is it Government of India, Archaeological Survey of India, guidelines?
Guideline, individual that was in specific monuments wise.
So how are you saying only Odisha?
That is specifically
Because ASI has monuments all over India.
All over India.
Yes.
For that purpose.
It is not mentioned that it is only for Odisha or only the Konark temple.
My lord, your lord said.
The application shall be addressed in favor of Superintendent Archaeologist Bhubaneswar. Not the
page 40.
Not page 40. Serial 8. On receipt of the license fee. After selection, 7 pages. 7.
Yes.
Huh.
Sorry.
So 2007, even if you had been granted that license, that was valid for 3 years only.
Then there would have been a renewal for that. They could not have.
No.
Then you would have also, this is the discerning fact. Had we been granted, my lords, we could have also claimed parity, because another class, that would have been another class for, my lords.
This writ petition was filed when?
2015.
And you could not pass matriculation examination.
No, I have no idea on that.
Therefore,
That,
you cannot pass matriculation examination.
my lords, it's a photography. For photography, my lords, what matriculation? It's only a question of, my lords.
Right. See, if some Einstein was not required to pass matriculation or this.
No, we are not
Or
Einstein.
even Newton or any scientist. So if you ask him to pass this intermediate examination, or they would have failed.
It is a question of
This is
knack
not
also.
this is, see, Mr. This cannot be the summation that because this is photography and therefore no minimum qualification, educational qualification can be laid down.
Because they have laid it down because they are
If
national.
you are a photographer of that quality, then you are not required to go there. There are people to take your photographs.
My lord, but we have been discharging our duties without any complaints from anybody, not even them. Not even them. There has been no complaint that the quality of photographs taken or.
My lords, 300, 400 photographs entering. So far as
That's a
manufacturer,
different
only
issue.
78
Quality
numbers
of photograph.
are allowed.
No. So many
Yes,
photographs
there is-
are entering, there is no
Why are
necessary
you
for
making this
tourists.
summation that there should have been some complaint against you?
No. I think quality of photographs.
Who is going to assess that?
That I was only.
No, another thing, you are agreed by the 2017 guidelines. Why did you file in 2015?
No, there's an amendment. 2015, when they stopped us from going, we came. That our applications are already pending. You have not granted us the license.
See,
and
the
you're-
life of your application expired
My lords.
in 2010.
My lords. My lords, had we been granted. But in 15, they suddenly stopped us and they said you obtain a license. Then we came to this court that we have already applied for license. That is part of the record, my lord. We have already applied for license. You are not granting us license.
All right.
Yet you ask us to obtain license and you are stopping us. That is how your lordship granted, my lords, as the. And then when the 2017 guidelines came in, my lords, we have challenged the 17 guidelines by way of an amendment. Amendment was also allowed by your lordships.
Yes.
What is this identity card?
Identity card was issued by the tourist officer.
Only 1 year. Earlier also you have got.
No, they issued us one. It continued. It continued. Yes, whatever was available, my lords, we filed.
21 to 22.
21 to 22, subsequently.
That's all.
My lord, I'll file a short note if you want.
Yes.
We are intervenor supposing them. We are intervenor supposing them. Our petition on the same day was allowed. Only that portion that your lordship may look at. And they have not annexed. We have filed that.
They have accepted that we will apply under the new guideline.
We said that we will apply within as per the new guideline. On the same day, my lord, Honorable Single Judge disposed of 2 writ applications. Our was one, we have the licensees who have gone through the frontal process, appeared in the.
There are only 10.
10 are before your lordship out of 78. Because
They want to corner the entire.
Please.
It is a wild heritage, my lord. This English or 12th standard, 10th standard has its own meaning. That is another aspect, my lord. Policy, your lordship may kindly look at next year E, flag Y. There, the honorable single judge, I'm placing 2 paragraphs. This was our instance of our petition where they had appeared, but they have not made us participate. It will appear that the interim order was based on the license granted by the tourism department. Lower license issued by the tourism department has been disclosed. Opposite parties, including the administration, will ensure that all persons who claim entry to precincts or protected monuments in the state by showing license granted by the tourism department do so. You know, do so to carry out that which is permitted by the license. It follows that apart from tourists, only those who have valid license for purpose of conducting photography. Page 40, your lordship. Para 40. It is pursuant to such an interim order, their clients were entering precincts of the protected monuments with photographs and arm their library. They will, in the meantime, apply for issuance of license under the new guidelines. On query from court, Mr. Guru submits his clients take photographs of visitors who visit the Sun Temple at Konarak. Mr. Sharma learned counsel additional government for the purpose of ascertaining whether the intention of such and such permitted contravention to good, it is necessary to extract test with such and such. Then, my lord, finally they say, honorable and simply just say, this it follows that apart from tourists, only those who have valid license for the purpose of conducting photography in precincts of the protected monuments are allowed to enter. This must be complied by the ASI in the assistance of the administration. The necessity for compliance cannot be overemphasized because monuments are ancient and they are need to be protected. This order has not been challenged by this. So they have participated in their parties. And the collector also said, my lord, that annexure T is 36. The tourist officer Konark present in the meeting informed that the tourism guide letter dated such and such 1/11/22 informed that the department have not issued any identity cards to any photographers for carrying photography business at Sun Temple Konark. However, Director Tourism guide letter dated 7/2/2008 intimated that the then tourist officer Konark had issued identity cards to 110 numbers of photographers in the year 2002. Neither the copy of the identity cards issued by the then tourist officer nor any order of the tourism authorizing the then tourist officer to issue such identity card is available in this office. In such a situation, the authenticity of the identity cards issued by the then tourist officer cannot be verified at this level. Pursuant to lordship direction, this inquiry was made.
Yes.
Yes.
Identity card, not like this.
Adding livelihood in the honorable Delhi High Court judgment also. 4.4 deals with that. Livelihood has been is discussed. The petitioners have been working as photographers in ASI protected monuments since 2012 to 2016. They work as photographers in the protected monuments at Agra, including Taj Mahal, Agra Fort, etc., without any complaint from any kind. The petitioners over the years have professed photography is the only medium of livelihood and profess their job with passion. Therefore, it is prayed clause 2.7 of the amended ASI photography policy to the extent the validates license granted prior to 2012 to the exclusion of other photographers like the petitioner request and satisfied. This was also taken into consideration by the and fact is they have no license. We are the only licensee out of that 78 sanctions. Every monument has its sanction set basing on the footfall of the tourist, my lord, and to which places they are coming and all that. That's why this criteria regarding educational qualification and other aspects.
Yes. Next.
Item number 16.
May I please? My lord, here the petition number 6 is dead, and I have filed the application for substitution. Substitution. Which one I am but prosecution again. আমি দিয়া ହେଇଛି ଏ ଦେଇଥିବେ ଯେ ମୋ ପାଖରେ ନାହିଁ ମୁଁ ଆଉ ଗୋଟେ ଦେଇଦେବି
Yeah, number 15507.
my lord 550
2024. Oh, this application has been filed for substitution consequent upon death of the original petitioner during the pendency of the unit application. Petition number 6.
Petition of 6 man.
During the pendency of unit application. The name, the description of the heir / legal representatives proposed to be substituted has been given. Where have you given?
I have given in my schedule my
In schedule. In
schedule page 2 of my IA.
schedule. Instead application. Full stop. Even he may not, considering the requirement made in the application, the same is allowed. Let the persons mentioned in the schedule, names of the persons mentioned in the schedule be substituted in place of petitioner number 6. Yes.
Consolidated cost title I will file one.
File, but whether there is any merit.
No, so one thing I think whether will also accept it, say writ application challenged in the orders passed on the Survey and Settlement Act. And the assignment is honorable single judge assignment. So
Why it has come before this?
That's why, because mutation, then appeal and challenge is to the orders of the Tahsildar for mutation, and thereafter appellate authority, that is sub-collector.
So there is no revision.
I think revision power is also there, under the Orissa Survey and Settlement Act.
So you could have filed revision application.
Revision is 42.
It was being listed before the single judge.
So once it was transferred.
Tagged, I think. It was till
So you could have
21/5.
preferred a revision application. Why have you filed?
The revision, my lord, revision was filed.
Then?
Annexure 10 is the order passed by the.
But that is not under challenge. The challenge is only to the prayer.
No, that I have one.
Prayer only challenge to the order of the Tahsildar and the sub-collector.
8 and 6.
And revision is provided under section 42 capital A of the Survey and Settlement Act.
Well, the cost title, my lord, initially it was written that the matter relates to Orissa State Abolition Act. So
that is why it was OE Act, so it has been placed before Lordship Division Bench. But it's under the Servant Settlement Act, my lord.
Was it a batch matter? Because I'm looking at these orders, was it a
Yes, the
batch?
Madam?
There is one WPC 10876.
376.
10376. Where did that go? 10376.
By 2015.
Because the order sheet contains orders passed in that. देख ले 10376 of 2015 वाला footage. 10376 of 2015.
But why have you not challenged the order of the revisional authority?
Appellate authority.
Revisional. Consolidation settlement, commissioner consolidation is.
Restoration, sorry, no. Alternate remedy is there, and again it has review petition has been allowed and
And subsequently I filed a review application that has been restored.
then this has been dismissed for default. 10376 has been dismissed for default on 19/1/2023.
10376.
Restore this. 10376 dismissed for default on 19/1/2023.
A revisional authority, why have you not challenged his order?
Not challenged.
It's 60. Have you challenged? 9/9/2005.
Your lordship may call it on 22nd. Because my lord, very recently the file has come to us. We'll verify and on that date, my lord will answer.
That is, only something else.
Remedy.
Must have been said.
No, Rule 34 of the rules has been exhausted. No, the connected matter. This is 28 of 242. This is the reference to this case in that.
So these two cases are different. There were two matters. One is 16648 of 2011 and the other WPC 10376 of 2014.
Yes, well, but in fact, as per the order passed in WPC 10376 of 2015, the mutation case was taken up for recording the land in favor of the petitioners. Thereafter, my lord, it was rejected. Challenging that, the appeal was preferred. And in appeal, it was confirmed. Challenging both the original as well as the appellate authority's order, this petition has been filed.
The council,
Yes,
this is of 2011.
Yes,
2015 11
15 you have stated that you have challenged it because some demolition of your construction.
That is another petition, my lord.
That is why GA department was made a party.
So that is how. That has now been dismissed for default. You are not aware of that.
No, I am not aware.
Then the whole building will go now.
So why don't you approach the revision authority?
Your Lordship may grant some time, verify what has happened in that.
All right, we said grant you time, but please come to page 52, annexure 10.
That has been dismissed for default.
The order passed by the
Division.
No, this is the final. No, but this is of 2005.
Five.
Oh, this must have been set aside. This order must have been set aside, Mr. Counsel. The final order passed in this.
File a miscase for restoration.
Lord, I'll verify at the record again. Then
Mister, please come to the notes of submission. Why
the note of submission, so to speak.
you did not challenge that revision or review? That order.
In the index, they've said that order passed by the Commissioner of Land Records Annexure 10. But prayer, there is no prayer to say.
No, that order was passed in 2005. 2005.
Yes,
Now, these orders have been passed in 2007.
right, ma'am.
So, what happened to that order, annexure 10? Because in the written notes, it is stated about annexure 10. The petitioner approached this court through successive writ applications apprehending disposition.
Annexure 10 contains two orders. One is the revisional order, the other is the order in the settlement miscase.
That revisional order, my lord, that revisional order, what happened? Last paragraph, however, the special counsel for the GA department accordingly has got stale property, the claim of the person could not be reconsidered, the case is disposed of. Subsequently, review miscase has been filed and the matter has been remanded to the Tahsildar. This case was reopened, last paragraph, my lord. In view of the above, the Tahsildar Bhubaneswar is directed to examine the correctness of the records in view of prayer of the petitioners to conduct.
Where is that?
That is.
So you are not agreed by this order. 9 September 2005, you are not agreed.
That order, your lordship, subsequently.
Because you have given annexure 10, both the orders you have given the 2005 order and this subsequent order.
A subsequent order, that order, your lordship, kindly see ordering person. There it has been reflected, a writ application was filed in 2006, my lord. The petitioner filed a review petition getting miscase number 32 by 2006 out of RP case number such and such. The delay was condoned by the order dated so and so. The petitioner has also filed a case law of Honorable High Court order dated 16/1/2006 in WPC number 13309 of 2005.
Please be clear on facts. When counsel appearing on behalf of the petitioners is not ready on the merits of the case. So I have requested let this matter on 22nd.
Please give a comprehensive date
Yes,
chart.
yes, madam.
All right, and you check up the other case. What has happened?
Yes.
Item note 17.
I'm appearing on in the last one item, Your Lordship. The matter is relating to the petitioner claiming the benefit of revised scale of pay of OS 198, Your Lordship. The assignment is of only a single judge, Your Lordship. It is assigned to Justice.
Matter for appropriate single bench according to the assignment.
Along with the connected matters.
My lord, earlier there was a judicial order, this case, that since the virus of the statute has been challenged, so matter has to be placed before the division bench.
Which is that order?
That was on 21/1/2016. Well, that is in the writ WPC 6243 of 2009.
What about the virus?
In fact, the resolution of the state government under challenge that it is not in conformity with provision of the
So where is the order, judicial order?
the judicial order 21/1/2016 in WPC 6243 of 2009. That is the second item, second sub item.
Order dated?
Order dated, my lord, 21/1/2016.
But resolution declaring a resolution.
Yes, so it is
that-
not a virus. So it has to go before the single, but this order was.
In my case, I have not challenged the resolution, Your Lordship. I have claimed for the.
Because it says illegal, arbitrary and violative of Rule 9, not that Rule 9
Yes,
is
but
violating
that
it.
order was earlier order was there, that the matter was.
Resolution is challenged, that should not come up
No,
before
no,
a division bench.
no matter. Has to go before.
Oh, but where is the order that should be placed before division bench?
That order. Order dated 21/1/2016, which says.
Page number 30.
In 6243 of 2009, order dated 21/1/2016.
Thereafter, the matter was never taken up.
Thereafter, the matter was that particular matter was listed before my Lord Justice Rotha sitting in single bench on 2/8/2022. And thereafter, yeah, and
The
What
same,
is-
same thing.
What is the point involved? You can decide. What is the point involved?
In my case, Your Lordship, the petitioner is working as a teaching staff in an aided education institution. As per 1974 rules, Rule 9, Sub Rule 1, the employee of an aided institution is entitled for all the benefits which is been given to a government employee. So in this case, after 1998 OSP rules came into force, when their pay of scale was not revised as per in terms with the government employee, they have approved this honorable court. Now, this honorable court, I'm sorry, I've got one copy, Your Lordship. In the case of Dipti Roy, has already decided the issue by interpreting Rule 9 of 1974 rules. I'm sorry because I'm not prepared, Your Lordship. I thought it would be before a single judge. I got the one copy of the judgment.
I have not directed to be placed before the division bench. I have said that it had been directed to be listed. What happened thereafter is not
Yes,
known,
yes.
so list.
List, yes. So
So I
it
was
has.
thinking probably mechanically I passed that order,
Yes.
I have not.
Revisions. If you are on pay revision.
There was a time the registry used to, without taking orders of the Honorable Chief Justice, it used to list matters like this. There is no order.
दो कॉपी डेफिनेटली देखा है तो कॉपी जजमेंट को पढ़ने
What happened thereafter?
Your Lordship. Now thereafter, they have given me the revised scale of pay prospectively from 2003. Now I have approached this honorable court in another writ application bearing WPC number.
No, what happened? This was the law laid down by this court.
Yes, Your Lordship.
What happened?
They have given them the 1988 rules came into force with effect from 1/1986, Your Lordship. Now, after the pronouncement of judgment, they have given all the benefits of the revised scale of pay with effect from 1/1996. But in our case, we have been given that revised scale of pay with effect from 2003, prospectively.
Why?
My lords,
Why?
that is the subject matter of challenge, Your Lordship. That is the subject matter of challenge.
What is their stand?
They have not filed counter affidavit, Your Lordship.
They have not filed counter affidavit.
No, Your Lordship.
Second application has a counter.
Second application has a counter.
But I don't have that copy of the counter affidavit or not served on me also.
Copy not served. And pursuant to order dated
And in
14th
that case, Mr. Das is appearing. Suppose he is attending somebody's
We
funeral.
should
Your
stop taking up 2024 and 2023 matters. This is 2008 and no counter affidavit has been filed 2009.
A counter has been filed in one of the case. That will.
All right. Do you rely on that counter affidavit for all the writ petitions?
Well, that counter affidavit will cover all the writ petitions, but there are also statutory rules and arguments which are to be.
Those statutory provisions are not required to be incorporated in the counter affidavit. What is your stand?
Well, stand, my lord. Here, what has happened, your lordship may kindly appreciate. My lord, so far as that fifth pay revision that was made applicable so far as state of Odisha is concerned, as per the recommendation of the fifth pay commission, a rule was framed in 1998. that was in retrospective effect from 1/1/1996. Now the rule puts a specific bar that the rule is applicable to the whole time employment of the employees who are in whole time employment of the government. So these petitioners, so far as these petitioners are concerned, they are not the government employees. They are the employees of non-government aided educational institutions. So these rules directly doesn't apply to them. They cannot claim any benefit pursuant to this rule, 98 rules. Now, various applications were made before the authorities. Then authorities took a decision in 2002 that the benefit that has been extended to the state government employees will be extended to them. But that was made applicable from a prospective date, but because that notification came later in 2002 and they were given the benefit. The provision he is referring to, that is under the 74 rules 92B, that provision, if your lordship will go through, that provision said that they will be entitled to the similar benefits as has been granted to the state government employees. So here the state government took decision to extend the similar benefit. But the rule doesn't say from which date it has to be made applicable.
So this is your case that because of 2002 decision,
yes,
they do not become entitled to every benefit which a government servant is entitled to.
They have been made entitled, but
Right.
not from, yes.
Every benefit means with effect from the date since other employees have been granted that benefit. This is your submission.
Yes.
That had there been no 2002 decision,
Yes.
they would not have been entitled to
Yes.
anything.
Obliged.
So this is your submission.
That is the submission so far as legal submission is concerned. And in a similar nature of case of my lord, Maharashtra State Financial Corporation employees, there were two issues raised before the Honorable Apex Court. In fact, it went from the High Court and two issues were involved. One, with respect to...
So please give him a copy of the counter.
I'll give him a copy.
Give him a copy and then we will. So the subject matter of the case of these cases is assigned to assigned to the bench under the rules. It seems that because of an order dated, so what is it?
21/10/2015.
Of an order dated 21/10/2015 passed in
Batch case 15302.
passed in WPC number
15302 of 2011 and batch.
15302 and batch. This matter has been placed before division bench. What's up? Next, be that as it may. AGA representing the state of Odisha has submitted that counter affidavit has been filed in WPC number
6243 of 2009.
6243 of 2009, which he shall be adopting in other cases also. In the present batch. That's all. Let a copy of the counter affidavit. Said counter affidavit be served on learned counsel for the petitioner. appearing in WPC 16917 of 2011. You are appearing in this case?
No, your lordship. I'm appearing in WPC number 19951 or 112. Last but one item at page number 12.
19951, 2012.
199.
But in other cases, my lord, nobody has
So
appeared.
same counsel is there?
No.
No,
Different
for the
counsels.
petitioner.
For the petitioner, nobody is appearing except
Starts there in most of the cases.
he is not.
Tomorrow.
Is he coming to court?
I don't know.
So this matters on 22nd. Order.
Cases, Mr. Ramchandra Rai is appearing.
Can you inform him?
I believe.
Please inform him.
I'm great.
Item number 8.
OPS.
Must have become infructuous. 2011. Nobody appears for the other side also.
No, but see this.
15.
Let's see what is there. Compromised.
Yes, sir. Last order was no representation. I'm taking that.
Pursuant to court's order and application for. We feel there is no representation on behalf of the petitioner.
Or the opposite.
Or the parties of this application is accordingly dismissed for default.
Item 19.
No, it does not appear in last order.
On the last date also, there was no representation on behalf of the petitioner.
Item number 19. Item number 20.
Well, previous order, Lordship directed.
Yes.
Lordship directed for filing an affidavit concerning to this street vendors. I'm filing this affidavit. It has been constituted and the rule has been framed by the state of Orissa in 2015. Subsequent to that, the committee has been constituted. So I have filed all this. The whole issue, my lord, after the discussion with the commissioner, the situation is there are certain marketplaces constructed by the corporation. If Lordship will consent and if they agree, they can make application, we can adjust them because there are 25 in number. So we can adjust different places where vacancies are there. The marketplace constructed by the corporation, particularly Unit 4 area and areas which are within the radius of 2-3 kilometers, 5 kilometers. Like this is what we have hinted. If at all they are interested, they can be adjusted there.
Mr. Patnaik, has petitioner number 1 withdrawn from the case?
Again,
Petitioner number 1, has he withdrawn from the case?
no, she expired.
Substitute.
Expired, no?
Wife has been
Right. That is why the name.
amendment on that.
So in view of the stand which they have taken, we can.
No, I will take from Mr. Mohanty is not there. He's the original counsel.
He was there?
No, Mr. Mohanty, Ashok Mohanty was doing the case.
He was here.
I am his associate. No, he is in election another court.
Okay.
And another thing, I have taken instruction on this. My friend has requested me to receive the counter and take instruction from the party. And file a response to this.
Para 7 is very clear.
No, I will file a response. You have not seen the just now. You
We can make an application, we can have, because
I will take a
25
response to
persons
that.
in one place cannot be
Take
addressed.
instruction on this and file a reply to this.
As you wish.
Madam.
As you wish.
No, that is my only submission. Madam.
They can recall the affidavit also.
No, I have received a rapid just now.
No, we are not taking this. Land counsel appearing on behalf of the corporation estates, Municipal Corporation Estates, that he intends to file a counter affidavit in compliance of the previous order of this court. So let it be done. So, copy of the counter affidavit proposed to be filed has been served upon land counsel for the petitioner. This matter on 22nd. Do it in the registry.
No, in this case also, your lordship directed the Housing Urban Secretary to file an affidavit. I have obtained the instruction, my lord. So I will file that affidavit.
File an affidavit.
My lord.
Item 21.
Why interim orders will continue?
It is there since long, my lord.
No,
Continuing since long.
sorry. Sorry.
I'm 21.
The case, for instance, on the basis of suspicion, a lady member of this honorable court was arrested. He was arrested in a peculiar manner. He was moving with a scholar of American scholar who was doing research work on the industrialization and aftermath. Industrialization in Orissa and its aftermath. The American scholar was came to this place, my lord. There was a public meeting in Bhubaneswar.
So what is your relief?
Relief, my lord. Relief is twofold. One, my lord, I need to be compensated. They have falsely implicated me in 2 cases, and in both the cases I have faced trial. I was incarcerated inside the custody for 2 years, 3 months, and 5 days. Thereafter, no evidence, false implication. They interrogated me without a ready police officer throughout the night, my lord. No arrest memo was applied. And all this, for this malicious prosecution, my lord, I pray for compensation. This is my first prayer. And initiation of proceeding against the erring police officer, my lord.
That is very difficult.
My lord, if that is, my lord, if it is found that in the case of S. Nambiar, my lord, in Kerala, my lord, on the allegation of espionage, now he was put into custody for so many days, incarcerated, approached the court, my lord. And when the court came to the finding that the prosecution is malicious, my lord, then only adequate compensation under the public law can be granted, my lord. And
that can be done, but
my lord. Here, I have filed the written note. Almost, I think, the argument was over in this case, my lord. Written note of argument, date chart, everything, my lord. Now today I'll supply date chart, my lord.
Then you are relying on who awarded compensation?
Yes, I pay. And
Who awarded compensation?
State, my lord.
No. Who awarded? State awarded?
No.
It was directed. Who passed the direction?
Court, my lord.
Which court?
My lord, the Supreme Court.
Yes. After the proceedings were quashed by the Supreme Court.
The proceeding was ultimately court. Yes, my lord. It was
Or you were acquitted?
Yes, I have.
Acquitted, and the appeal went up to the Supreme Court, and the Supreme Court dismissed the appeal and thereafter granted compensation.
No, there CBI found that he was not involved. But again, when the matter came to the court, my lord,
State police filed objection saying that no, there are some wrong infractions in the investigation by the CBI, and thereafter the prosecution was allowed to continue. He was put inside the custody for so many years, my lord, and then thereafter this.
And it is a procedure for malicious prosecution. You can apply as per after your acquittal.
Right. These are all, my lord, there is a bunch of judgments, my lord, wherein in the first case, my lord, lordship may come to pay para 31 of the judgment, of the judgment, my lord.
Oh,
Of the judgment in case Nambiar case, my lord.
what is there? What is there?
They say, as stated earlier, the entire prosecution initiated by the state police was malicious and it has caused tremendous harassment and immeasurable anguish to the appellant. It's not a case where the accused is kept under custody and eventually, after he is found not guilty. The state police was dealing with the extremely sensitive case, and after arresting the
In
appellant.
your case, there was a trial.
Yes, I faced trial, my lord. Both the cases, I was implicated.
In that case, there was no trial.
But they are.
So is this your case that whenever a person is acquitted of a charge in a criminal case, he should be compensated?
My lord, not in all cases, my lord.
Right.
Here, my lord, she, on the basis of suspicion, she was arrested. She was handcuffed. In one occasion, she was handcuffed. There was no occasion. There is guideline of the Supreme Court regarding handcuff, my lord. Now she was handcuffed. She is the lady. She was interrogated throughout the night without the presence of a lady officer, my lord. Now the whole intention behind.
So you file this writ petition after the acquittal, or?
Yes, after the acquittal. Both the cases I have acquittal.
So
Thereafter,
after the handcuffing, I don't.
So you could have approached that you have wrongly been handcuffed. When she was handcuffed.
while I was implicated in one case, I was implicated.
Right. When was the case lodged?
Case lodged in 2011, my lord.
And when were you acquitted?
But acquitted in 2000. I'll give the list.
10.
10, my lord.
So again, tell us, when was the case instituted?
My lords.
When was the case instituted?
Instituted in 2011, my lord.
And you were acquitted
No,
in
here.
2010.
No, I have filed the case here in 2011, my lord. Case was instituted in 2008, my lord.
2008,
my lord.
You were handcuffed in?
In the during my stay in Kuchinda jail.
Handcuffed in 2008.
10, my lord. 2009 I was handcuffed.
Why are you raising this grievance now in 2011?
No.
Did you raise this grievance immediately soon after you were handcuffed?
No, only after I was acquitted, and again I came to join in this profession, my lord. I took some time because that was a tremendous harassment. I was mentally shocked, not in a position to immediately approach, my lord. That was I have taken, my lord. And when I approached this court, then I raised all these points, including handcuffing, my lord. That is what. My written note of argument, my lord, I think it will suffice the purpose. For if you lord permit me, I'll go through it, my lord.
No, not required. We will go through.
The list of dates. Can I go through the list of dates?
No, not required. So if there was no material against you,
Yes.
then how the charge was framed against you?
That time, my lord, they have framed the charges, my lord. Basis of some documents.
Who framed the charge?
My lord, charge was framed during, in one case, my lord,
Who framed charge?
my lord, charge was framed by the court, my lord.
By the court.
Yes.
So that was also malicious?
My lord, that I cannot say at this stage.
Mister, if you cannot say that.
My lord, prima facie court found that that is something, my lord.
So therefore, prima
Yes,
facie, you were sent to custody under
Yes.
the orders of the court.
Yes, yes.
Judicial custody.
Yes.
You were under judicial custody.
Yes, my lord.
Charges were framed.
Yes.
That the court will have to presume
Yes.
that the court, you did not, did you file any application for discharge?
No, I am not.
You did not file any application for
Yes,
discharge.
yes.
Thereafter, you were put on trial.
Yes.
At the trial, you were not found guilty. You must have been given benefit of doubt.
Your he has examined, the court has examined all the witnesses. It's not that on merit, my lord, it has decided. They said that there is no semblance of any evidence so far as the prosecution.
Sir, there is difference between clean acquittal and benefit of doubt.
My lord.
If there is evidence to the effect
Yes.
that you had not committed the crime,
Yes.
then the court may record a finding of your clean acquittal. But it is because of lack of evidence, then you might have committed the, but because of lack of evidence, you are to be acquitted by
Not
giving.
lack of evidence, my lord. Here the prosecution witnesses, they said against the prosecution, saying that no, this is only in blank paper we are made to sign, all these things, my lord. So on merit it was
This
decided.
happens. This happens in every case. Caesar list witnesses turn hostile.
No, my lord,
We will explain.
the very action from the initiation, my lord.
Very
What I
action-
say, my lord,
very-
they have
see,
arrested.
That Mr. Very action from initiation you could have approached. You
But
do not file even
Lordship
any
may
application for
consider
your
the
discharge.
position of the girl, my lord. Now, her father was a OTM employee who has been retrenched, my lord. OTM was stopped. No, that's true, my lord. I think, my lord, this is, that's true, my lord. My lord, in all the, I have given all the judgments, probably what to my, subject to your lordship's
We will
appreciation.
surely.
Lordship's appreciation. I have given the
22nd crore.
copy of the judgment.
It will come on 22nd. We will see. Yes.
Do not the same thing your lordship have already. So that is the thing. She had the urban Naxal. She had Naxalite links. Actually, so therefore,
That we cannot say.
that is not after the acquittal.
That we cannot say.
And all the bail applications also were rejected, detained under the orders of the court.
All right. Just a minute. One matter, there is some typographical error that has to be corrected.
Item number 41.
41.
That we are talking
Yeah, it is a disposal matter, my lord. There is a error and apparent on the face of the court only because the case number has been wrongly mentioned as 4369 of 2023 instead of 4369 of 2023. 2003, my lord.
2000. All right.
Appropriate order may be passed. Oblige, my lord.
Yes, we need to rise. Yes, please.
Rest of the matter should be taken up tomorrow.
Not
Friday,
tomorrow,
evening.
next Thursday.
Next Thursday.
Because all the old matters are coming on Thursdays.
Diplomat.